What I was suggesting, subject to Lordship's permission, let the matter be called on at 3 o'clock.
Correct.
But I won't be.
No, that's why any junior let me present, and I will check my diary because my officers are not here. As per the diary, then I will fix continuous 2 or 3 days, whatever, as per the convenience of the day.
I'm good.
Thank you. Thank you.
Lordship, may I kindly be permitted to mention an urgent matter for leave? Lordship, the petitioners are the continued cultivators of a plot of land. Lordship, therefore, the petitioners had the Borga records of the plot of land, and after that, a land was wasted by the government, and therefore, the petitioners had several times sent representations for the for patta settlement, and therefore, no representation was heard, and thereafter, suddenly, the land the petitioners are the continuing cultivating on the land, and suddenly, the police officers are coming and taking the encroachment of the land and without any prior notice, and therefore destroying all the crops of the petitioners which are there in the plot of land. Therefore, the petitioners, this is the only sole means of livelihood for the petitioners, Your Lordship. Therefore, it needs an urgent.
You are the recorded tenant.
Yes, Lordship.
The owner of the property.
Yes, Lordship. The petitioners had the Borga record of their father's name, and thereafter the petitioners had made several representations from the year 2002 for the patta settlement. No representations was heard, and thereafter now they are without any prior notice, without any prior information to the petitioners, they are just threatening the petitioners to
now what you
to vacate the land.
So what you want?
Lordship, to the patta settlement, Lordship, a matter is already been pending in the LRTT. The matter is already pending in the LRTT, London LRTT, Lordship.
Correct.
And thereafter, the police is now without any prior permission coming and taking encroachment of the land, plot of land.
So what you want here?
Lordship, the matter should be heard as the.
Have you filed any application?
Lordship, I'm filing for leave, Lordship.
What is the urgency? You
Lordship,
file it, then let.
Lordship, the petitioners have their cultivated crops in the plot of land. The police.
When the police entered into a premise and the.
Lordship, just the day before yesterday, Lordship, and they are handing over just notice and they are threatening about just to vacate the land, Lordship. Lordship, this is the only means of livelihood for the petitioners. They are the Lordship, they are the poor farmers of the land, Lordship. This is the only means of livelihood for them.
Leave is granted to affirm the affidavit and to be listed as urgent motion on Wednesday.
May I be permitted to grant leave for leave matter, my lord? Petitioner is a practicing advocate, my lord, and he is appearing in the AIB examination. Her enrollment number is wrongly published in the admit card. Examination is fixed on 30th of this month, my lord.
When you got the admission card?
Admit card is received, my lord, on 16th of this month, my lord. And we have repeatedly sent representation and called the help desk. Nothing has been done, my lord, till date. But I am praying for leave, my lord.
So what you want?
For correction of the enrollment number in the admit card.
Enrollment number of the petition. So how you can connect that is the correct enrollment number?
My lord, I have received enrollment number from the West Bengal Bar Council.
Correct.
That is not correct that is not been published in the AIB, my lord. AIB admit card.
The enrollment number, the admit card you have received?
Yes, my lord. I have received. My candidate has received.
By the wrong enrollment number?
Wrong enrollment number.
Have you inquired from the Bar Council?
Yes, my lord.
So what they saying?
They have said, my lord, they can do anything. It is to be done by the All India Bar All India Bar examination, my lord. BCI has.
When the exam is there?
Examination is on 30th of this month, my lord.
30th of?
This month, my lord. 30th November.
On working day?
Sunday, my lord.
30th of November?
Yes, my lord. 30th of this month.
26
My lord.
Urgent. New motion come on.
My lord, for
today mentioning date.
One matter for
Tuesday and Thursday. Tuesday and
my lord, this is
one
for
matter for non-prosecution.
My lord, this for non-prosecution. I have
come on Thursday, Tuesday. You mentioned non-prosecution and new motion, whatever it may be. Only the today I am taking as there is urgent. Yes.
Your lordship. Your lordship. Hello, extremely urgent. Vacation bench matter. Extremely urgent. Since
come tomorrow. Come.
Your lordship, may I be permitted to mention one matter? Lordship, this matter was returnable on 20th.
Come tomorrow.
20th November.
Have your lordship kind leave to mention?
Come tomorrow, I am telling.
Your lordship, this item was wrongly listed on court number 10, lordship.
Get it released.
But we had a word over there. That was a misprint over there for the WPA number. The year 2023 it would be, but it would typed as 2025. So it was there on the. It should be there on the list of 20th November, but did not appear, lordship. So that's why, Sir Lordship, we are
mention tomorrow. We'll see to that. Yes.
But I am for the state led by Sheikh Mohammed Khalid, my lord.
You are for the
State, my lord.
who is for the petitioner? Why to be mentioned?
My lord, it is written for withdrawal, my lord.
Who has mentioned the matter? The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. But when the matter is listed today, under the heading mentioned, none appears on behalf of the petitioner, no accommodation is sought for, let the matter go out of the list.
I am appearing for the respondent bank, my lord.
My lord, I appear on behalf of the petitioners.
Your Lordship, I appear for the Election Commission of India, respondent number 1. I was humbly praying that it could be taken up on Friday or coming Monday.
Who has mentioned this?
My lord, I obtained a leave for urgency, my lord.
Yes.
My lord, the petitioners before your lordships, all the employees of a cooperative bank, Contai Cooperative Bank, they have been requisitioned by the district election officer to join the election duty of the West Bengal State Assembly election of 2026, my lord. The bank received the notice in the month of September. The entire process of registrations and the updations of the details of the employee has to be completed within 15th November. And the finalizations and the validations, my lord, has to be done on 21st 11. I mean the day I have mentioned before your lordships. My lord, nothing has been communicated to us. The 150 and over, my lord, the employees before your lordships seeking permissions, that seeking injunction against the notifications, that is at page 48 of your lordships. That is the immediate concern before your lordships. Page 48, if your lordships kindly consider the P1. This has been issued by the district election officer, and it is addressed to the main branch, Contai Cooperative Bank. And the bank authority board and the managerial staffs, my lord, they have received it in the month of September, if I'm not correct, I'm not wrong. My lord, the first paragraph, if your lordship consider the, if I may read it out, my lord. Reference above in view of the preparation of the election personnel database for West Bengal Legislative Assembly election 2026, you are requested to kindly check and verify the office information and the employee particulars provided in the portal EMMS portal.gov. whatever. The registration process of your office has to be completed before 15th October. And the employees' details have to be updated and verified positively by 21st 11. My lord, the bank authority did not do anything. Neither they have communicated to us. Us means, my lord, the petitioners before your lordship, the employees, my lord. My lord, if had it been informed to us, we could have take the appropriate steps, my lord. On the last day, they are collecting the name for updations and verifications in the web portal, my lord. My lord, according to us, my lord, it is our argument before your lordships, though the points is no more at res integra. In the prior to judgment of this Honorable High Court, my lord, in the single bench cooperative bank's employee cannot be under the purview of the section 159(2) of the Representation People's Act.
Correct.
My lord, the relevant portion of the judgment of the single bench, my lord, has been also annexed with the writ petitions for your lordship's consideration. My lord, this is the immediate concerns. Unless your lordships intervene and protect us for the moment, my lord, we shall be.
Your name has already been sent to the authority.
No. Nothing has been sent.
21st, they are not sent.
Your Lordship, we are the main answering respondent.
You are appearing for whom?
I am for the respondent bank, my lord. I have received the brief on Friday evening, my lord. I am yet to take the instruction. So I'm seeking.
Have you sent the name?
I
My lord, according to
instructed
us,
that
my lord,
regards,
according
my
to us, we the employees before your lordships, my lord, bank did nothing. No, no name has been sent, no verification, no updations, no.
Yes, madam. What is the
Your Lordship, I'm appearing for Election Commission of India. I was praying kindly take it up on Wednesday. They are required just for data entry, Your Lordship, not as a BLO. So, Your Lordship, this is required for the election purpose and the judgment is not applicable. Allow me to come back on Wednesday, Your Lordship.
okay? As per the prayer made by the council for the respondent bank as well as the Election Commission of India. Election Commission of India.
Your Lordship, Your Lordship.
Let the matter appear on 26th November.
Much obliged. Your
My lord, an
Under the-
interim
under
protection,
the
my lord,
heading
an
urgent
interim
motion.
protection.
Under the heading urgent motion.
My lord, any interim protection. Otherwise, you'll,
Come on that day. We'll see.
my lord, I shall, my lord, in the meantime, its bank is not prevented, my lord.
Election matters. How the blanket interim order can be passed? Let the file the let the bank say whether they have sent the name or not. Let they say what for the what purpose it is. Whether the law which you are taking the benefit that is covered or not. That
Lord.
has to see how the blanket
My lord,
order
at
can
least
be
any
passed.
any step should not be
Okay,
taken.
let come on to Wednesday.
On witness. Very well, my lord. I shall file my affidavit of service on that.
Yes.
My lord, I'm for the petitioner.
Yes.
My lord, the restoration application, your lordship. With your lordship, section 5, it's a 57 days delay, your lordship.
Yes.
My lord, restoration application, your lordship.
Where is your microphone?
Sorry. My lord, it's a restoration application, your lordship. With me at section 5, there is a 57 days delay, your lordship.
Have you gone through the order wherein your writ petition was dismissed?
No.
Have you read this?
Yes, my lord.
Yes,
If it was
read.
dismissed for default, my lord.
Kindly the paragraph 3. Read paragraph 3.
Yes, my lord. Yes, my lord.
So, court has gone into the merit of the matter. Your claim is time barred. If at all the court is restored, what about the paragraph 3?
My lord, I'm requesting you to.
The observation of the coordinate bench, whether the court can go about that the observation. Satisfy. If satisfy the paragraph 3, then I will go the paragraph 4.
The time barred outstanding penalties.
If the time bound outstanding you are claiming in the writ petition, how the court can restore your petition which has been dismissed for default? I don't know.
My lord, on that day, my lord, I could not appear. My lord,
But you satisfy the paragraph 3. Finding of the court. Satisfy that.
My lord, the client came to me later, my lord. So my lord.
Sir, I am asking paragraph 3. There is an observation of the court. From the perusal of the document, it appears that the petitioner is claiming the time barred outstanding amount of so and so. What remains? Can this court review that order by way of restoring your petition? Sitting in a coordinate jurisdiction. You are not filing an application for recalling of the order. You are only recalling of the order of the dismissal for default, not the observation. See the prayer in the application. What you have prayed for in the application? Where is the can? See the prayer. Condone the delay in filing the application for restoration, recalling the order dated passed by the sanction. So,
My lord, in this juncture, what can be done?
so if you say that yes, this is paragraph 3 also, then you have to argue the matter on merit, whether it is not a time barred. Show me. Here are 3 options.
My lord, actually, the client was a cattle feed supplier, your lordship, to the Mother Dairy Development Board. my lord.
When the last supply was made?
Hello, 2016.
Huh?
2016.
2016. When you raise the bill? 2016 is the last supply order, last supply.
Yes, my lord.
Then when you file this writ petition? 2024. 8 years after. In between, any part payment was made?
No, my lord.
Then
My lord, the
3 years.
respondents have not made any payment, your lordship.
That's why the last payment, last supply was made 2016.
Yes, my lord.
Correct. You made a representation, they are not made. Recovery of money should what? Recovery of money, what is the limitation?
My lord, but my lord, in this juncture, my lord, then the client will not get the payments. My lord, in this juncture, my lord, then the the petitioners, my lord, will not get the my lord, payments. Because my lord, he has supplied material, but he has not getting the payments.
I'm sitting in the advisory jurisdiction whether your client will get or not. The
No,
court is
no,
only
my lord.
asking
My lord.
whether your claim is barred by limitation or not. If your claim is barred by limitation, so how your client will get the benefit? Your client was sleeping for the 8 years. On 9th year, he came before the court. Yes, my amount is due. And you file the writ application. Tell me, what can be done?
My lord, petitioner represented through the learned advocate, but the
After 17, that is 2023.
2023 and not a party. He represented addressed to the principal secretary and chief executive officer and managing director, not a party in this writ petition.
Yes.
My lord, all the my lord, the respondents have been sought, my lord, and they are the parties in this
Correct.
litigation.
That's why you come to the page number 28, 25. 25. This is a notice given to you in 2017 to attend before the authority on 20 September 2017 to verify your respective balance. Got it?
Yes, my lord, my lord.
25. This is of 2017. Then kindly come to the reply 12th January 2017. That is subsequent prior to that. This is the last letter received by you on September 2017. After the
And
17, after the 17, you can now you come to the page 30, 2023, 6 years after.
My lord, kindly see the page 25.
Correct.
And no claim will be entertained after above the mentioned date. My lord.
Correct. That's what no, you cannot say, but this letter is September 2017.
Yes.
After the 2017, what you have done, there is no explanation. And you have given the legal notice on February 2023 after the period of 6 years. More than 5.5 years. Tell me. Record or not? The petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 7th October 2024, wherein this court has dismissed the writ petition for non-appearance of the petitioner for default. But in paragraph 3 of the order dated 7th October 2024, this court has also observed that inward comma. From the perusal of the documents, it appears that the petitioner is claiming a time-barred outstanding amount due as on 31st of March 2017. Today, when the application is taken up for hearing, comma, this court find that the authority, that is team leader, comma, HIMUL audit team, had issued a notice to the petitioner on 12th of September 2017 requesting the petitioner to attend the office on 11 a.m. on 20 September 2017 to verify their respective balance as on 31st of March 2017. In the said notice, it was also noted that no claim will be entertained after the above mentioned date. After the above mentioned date. Full stop. Petitioner has not mentioned in the writ application what has happened the notice issued by the authority on 12th September 27. After 12th September 2017, only on 20th February 2023, comma, the petitioner has issued a 2023, that is after the period of more than 5.5 years. The petitioner has issued a legal notice to the authorities, calling upon the authorities for making payment. Failing with, the petitioner will take appropriate legal action. Learned counsel for the respondent. You are for the respondents.
No, respondent number 3 and 4.
Respondent number 3 and 4. Draw the attention of this court to the representation dated 20th February 2023 submitted by the petitioner, wherein they said notice have been addressed to 5 of the officials, but none of the officers have been made party in the writ application. Consider the submission made by the counsel for the parties, peruse the materials on record and the order dated 7th October 2024. This court find that though the coordinate bench, though this court has dismissed the writ petition for non-appearance of the petitioner as dismissed for default, but it was also observed that the claim of the petition is time-barred. This court has also considered the document and find that the claim made by the petition in the writ petition is barred by limitation. Thus, no purpose should be served by restoring the writ application. Accordingly, this court did not find any reason to recall the order dated 7th October 2024 according can number so dismissed. Next. Consequently, the writ petition is also can already dismissed. Or क्या कहना चाहिए? Along with the can number so Yes.
IAPF for the respondent number 1 and 2.
My restoration application, my lord. My paragraph 4, Lord, you will find.
The order.
Order is the next one. It's dated 20th June 2025. It's been
June
dismissed for
2021.
default due to non-appearance, my lord, of the learned advocate of the petitioner, my lord.
20th June, when you
20th.
file the application.
2nd July, my lord.
Yes. Why you are not appeared?
Paragraph 4, my lord, I've stated. At the
Paragraph
same
4.
point of time, I was appearing in another court. Now, my lord, by the time I
That is
reached,
not
my
a
lord,
good ground for appearing the advocate before the another court.
my lord,
Several judgments are passed by even
but
Supreme
by the
Court
time, my lord, I reached, my lord, the matter was called, my lord. It was just, my lord, perhaps few seconds, my lord.
Yes.
My lord, normally I do not, but in substance, my lord, whether there is any merit in the writ petition, my lord may go into that also. It's a frivolous, absolutely frivolous.
What is the case? What is the?
I tell you, lordship, what happened, my lord. My lord, this writ petition, my lord, I'm the owner of a land, my lord, particular land with structures, my lord.
Correct.
Now, my lord, what, my lord, the respondent authorities have done, they have been carried, my property, my lord, is situated, my lord, in Eastern Metropolitan Bypass. Now, my lord, they have been carrying out, my lord, development work there, my lord. As a result of which, my lord, my property has gone down 7 feet from the road level. Now, my lord, I had made them representations, my lord. The final representation, lordship will kind, my lord, at page 33.
What is your
And
claim?
let them consider at least.
For what?
My lord, they need to restore because it is for their development work, my lord. My property has gone down, my lord. Lordship will kindly come to paragraph 6 and 7. My lord, my plan sanction, my lord, is stuck. Corporation is saying, my lord, initial, my lord, scrutiny was been fulfilled by me. My lord, this, my lord, situation is beyond my control.
But they are widening the road.
Yes, my lord, they have been carrying out development. I'm not standing on their way, but let them restore my land to the road level at least. Otherwise, my lord, nothing.
It's the widening of
But,
the
my
road
lord,
and they are
now,
raising the height of the
my
road.
lord, may I, my lord? Now, my lord, I cannot even do it without their aid. So let them hear my representation, my lord. Things can be sorted out. This is all I want, my lord.
Kindly have a look, paragraph 2.
Huh?
Paragraph 2. Paragraph 2, last line. When he purchased in 2006.
Yes,
Eastern
but at that
Metropolitan-
point of time, it was not going on. The development was
Eastern
going on
Metropolitan
subsequently.
Bypass was constructed in 80s. Yes, yes.
It was constructed, my lord, in the 80s. That I also know what my learned friend is saying.
When they started the work.
In 80s, that
No, my lord.
No,
Indian
when
bypass
the
was
present work,
It's a
when,
huge place, my
when
lord.
the present work was started.
4-5 years back, my lord.
Then
My tell you, lordship, my lord, at that point of time, the situation was not like that. It drastically came down in 2023, 2024. My lord, let them consider if they don't find it, that they cannot help me, my
what
lord,
we
they
will
will throw me
consider.
out.
It's a-
then the next litigation starts.
My lord, next litigation, my lord, no, my lord. My lord, because
So it will
lordship,
never end.
my lord, lordship will kindly appreciate, my lord. It is my property. I have the right to enjoy. I cannot do it. I cannot exploit it even commercially, my lord.
Yes, knowingly
Lordship will
purchased
kindly
in
guess my.
2006, which was complete.
No,
Everybody knows.
no, sir.
Everybody
Knowingly,
knows.
no one does this. No one hurts
Everybody
his own
knows
property.
that Eastern Metropolitan Bypass was constructed long back in 80s.
My lord, what I was, my prayer is innocuous, my lord. My lord, I am praying, my lord, let my, at page 33, my lord, let it be considered by respondent number 2, my lord.
Request your your land is lying vacant.
It's a vacant land, my lord.
It is vacant land.
There are structures there, my lord. I tell you, lordship, what is the practical problem? Lordship will kindly gauge this situation. It's gone down. Now, my lord, when I go for getting my plan sanction, fire is saying, no, sir, we won't grant you. In case of any devastation, how will you able to survive? That is the present situation. Now, my lord, I am a company. I cannot commercially even exploit that property. This is my practical predicament, my
So
lord.
you are the company, you take the permission from the authority to fill the earth and
My lord,
place your,
this, my lord, may I, my lord, may I,
height of
even
your
for
land
that,
up to the
absolutely,
road
my
level
lord.
and
I bow
listen to
down, my lord. Even for that, my lord, let them consider it because it's under
What
them,
should
my
we
lord.
consider?
My
Can
lord,
we-
things
can you
will be
review
sorted
the-
out. I am not,
Can
my
you-
lord, coming with any say dagger and trying to stab them, my lord. It's my property I am trying to save. What my prayer is very innocuous, my lord. Lord, you kindly takes up my representation at page 33. Maybe they won't, my lord, restore my property, but some practical, my lord, solution can be worked out. If, my lord, the author, if I can meet the authorities with my prayer, my lord. This is all I want.
You are knowingly you have purchased that land, low-lying land.
So
We
you
cannot
cannot say
reduce-
this.
we cannot-
Knowingly,
now-
I cannot purchase, sir. You cannot say this. It's for you, sir. This has happened.
It is
How
your
can knowingly I
petition.
purchase a property which has gone down from the road level?
It has not gone down in 2006 or 2008. In petition, you have said you have purchased in 2006. In representation, you have said 2008.
Okay, dispose.
What should we consider?
I tell you, Lordship, my lord,
Yes.
it a practical, my lord, solution will, my lord,
The petition
come into surface. If I can meet the officer, that respondent number 2.
present application being can number 1 of 2025. Praying for recalling of the order dated 26 June 2025. Which dismiss the writ petition for default on the ground that on call none appears on behalf of the petitioner. Counsel for the petition submitted. When the matter is called, the petitioner was was arguing the matter before the other court, due to which, and by that time the petitioner reached the House court. The court has already passed an order for dismissing the petition for default. Petition further submitted. The writ petition was dismissed on 20th June 2025, but immediately on 2nd of July 2025, the petitioner has filed the present application.
My lord, my representation is at page 33.
Counsel for the petition further submitted that the writ petition itself can be disposed of by giving it by directing the who is the authority? By directing the Kolkata Metropolitan Development Authority. Who is the authority to because you have met only the Calcutta Development. Who is the authority?
Respondent number 2, my lord. Respondent number 2, my lord.
Okay.
Respondent number 2. Acha, Chief Engineer.
My lord.
क्या बोला? No, directing the Chief Engineer from Kolkata.
Chief Engineer Road.
Within bracket Road, Kolkata Metropolitan Development Authority. Of the representation dated 14/5/2024. Learned counsel for the respondents raised objection and submits that the development of the Eastern Metropolitan Bypass was started in the year sometimes in 80s.
It is. It was completed long back.
In spite of having the knowledge, the petitioner has purchased the property in 2008. Now the Eastern Metropolitan Authority are widening the road by raising the height of the road. And as such, the authority cannot do if the land of the petitioner go down by raising the height of the existing road by the Eastern Metropolitan Authority. Had the learned counsel for the respective parties full stop. By sitting in the jurisdiction, this court, it is not possible for this court to go into the disputed question of fact. Accordingly, this court find that the petitioner has already made a representation to the concerned authorities on 14th of March 2024. That same can be disposed of by the concerned authority. In view of the above, can the order dated 20th June 2025 is recalled. Writ petition is restored in original file. Full stop. Consequently, the writ petition is disposed of by directing the Chief Engineer within bracket Road, Kolkata Metropolitan Development Authority to consider the case of the petitioner, consider the representation submitted by the petitioner on 14th March 2024, and if necessary, the personal hearing should be given to the petitioner and ask a reason in a speaking order within a period of 8 weeks from the date of receipt of.
They will provide me a hearing, man. Mal, Lordship.
Yes, no affidavit has been filed, my
As
lord.
though this petition is disposed of at the motion stage, thus the allegation made in the writ application is deemed to have been denied.
Much.
I'm grateful, Mal.
No use to keep it pending. That is
না না কোনো প্রয়োজনই নেই, এই তো আমি চাই তোমরা একটু সাহায্য করে দাও ভাই, বেঁচে যায়, কোর্টে ঝগড়া করে কি লাভ?
Yes,
I'm
next.
grateful, Mal.
Lordship, I am for the petitioner. This is a restoration
State
application.
respondents, my lord, it has not yet been served upon us, my lord, restoration copies.
So,
I'll have to check, Lordship.
No, we haven't received, nothing to check.
there is a can application.
It has been sent to Durgapur Municipal Corporation.
I am for the state respondent. Durgapur is a separate party, my lord.
Durgapur Municipal Corporation.
We both appear during when the matter was dismissed for default, your lord.
Serve the copy. Come tomorrow. Counsel for the state submitted no copy of the application is served. According to the petition directed to serve the copy of the application along with
Order sheet is naam nahi?
an access to
It is
the
number.
learned advocate appearing for the state.
Order sheet is number
In the course of the day, lead the matter tomorrow under the same heading.
GP office से ये phone लेना.
Come tomorrow.
Thank you. I am for the petitioner, my lord.
Well, I have annexed the order dated 18 September 2025.
Hmm.
That
None
none
appears
appears on the of the petitioner, matter was dismissed.
Correct.
Matter is very simple, but there is some. Well, what has happened, my lord?
Simple, but
Some wrong point is involved in.
if the point is involved, how the same person it will be a
The simple means, my lord, I have been taking. If your lordship kindly allow, then I open my mouth. Otherwise, it will be very difficult, my lord.
yes.
I have been mentioned in paragraph.
What you have prayed for? What is the petition? What is the prayer in the writ application?
Oh, very good.
Shifting
Well,
of
the
transformer installed.
Yes.
And
My
then
lord,
it required hearing.
No. The matter was heard twice before the honorable division. One of the honorable division direct the electric officer to inquire and to submit the report. Inquiry was made. It appeared from the inquiry that the transformer was installed within 2 feet from my boundary wall of the. Therefore, my lord, again I moved the Honorable Justice Pathira directed to.
Honorable Justice
But I will tell you, Lordship, but I am not, since my learned friend is saying that, but this case should be dismissed. Why I'm telling you, this is barred by limitations.
What?
And all, now let my learned friend open his mouth. It's a 2001 matter, and now this is a third round of litigation.
Yes.
I'm telling Justice Pateria.
But let my learned friend submit, thereafter I will submit.
But
So what has happened in that writ application?
My lord, I have been mentioned, my lord, the first order, my lord, paragraph 5. The order dated mentioned in P1, annexure P1. First order, my lord.
Correct. That is a liberty is given to you to make the representation to the authority. That is in 2004. You have stated in your paragraph, was pleased to dispose of granting a liberty to the petition to make representation ventilating the grievances to the Secretary Department of Power.
Yes,
You
my lord.
made a representation.
Yes, my lord.
Then what has happened?
Then, my lord, the secondary, paragraph 6.
Hmm.
That is the page 23.
Hmm.
The secretary of the joint secretary of the Department of Power and
Page
Non-Conventional
23,
Energy. Page 23, Annexure P2.
Correct. I find no logic to argument advanced by the so-and-so and direct the above mentioned society to immediately relocate the transformer so the minimum statutory clearance is maintained. The work shall be carried out by the cooperative society within 30 days. Yes.
At that time, my lord, the Singur Horipal Rural Electric Office was there. Now, therefore, that the Singur Horipal has been changed and coming to the West Bengal Secretary Board.
So what has happened after this order?
My lord,
Page 25.
Your Lordship kindly see that order. There have been inquiry, and it appears from the inquiry, my lord, that the installation of the transformer is only 25th. My lord, I have been page 24. The power department I have been reading, my lord. Last para. Power department had called an inspection of the premises by the West Bengal Secretary Board. He is an independent agency.
Kindly come to paragraph 20, page 25, paragraph 2.
Paragraph 2.
Yes.
Yes. Rabindranath Dev, and that is my father.
Under page 25, paragraph 2, under circumstances, I found no logic in the argument advanced by the Singur Haripal Rural Electric.
Yes, that is the respondent. I am not.
Correct. So this is the order. What happened after this order?
Thereafter, I made third representation. That is page 32 and 33, Annexure P3. Order passed by the Honorable Justice Pathiria. Page 32, 33.
Who was the petitioner before the court? According to respondent with the director depute.
Having considered the submission of the parties, it appeared that the order dated 30th September 2004 has not been challenged by the licensing company, nor an exception taking thereto. The order is valid and subsisting, and therefore there should no impediment to carry out the direction contained therein. Accordingly, respondent number 3 is directed to depute and authorized personnel to carry and give in effect the order dated 30 September 2004, parentally within 4 weeks from the date of communication of the order. And thus the writ petition has been disposed of.
Yes, then what after this order, what has happened?
Well, I made representation.
Then?
Nothing. A order was communicated. That is page 33.
2007.
And representation was further made in 25, 2000, that is page.
Who was the respondent number 3 in that order?
Respondent is Singur Horipal.
So now they are not there.
Now it is a West Bengal Secretary Board. That's why I make another petition. There is a third time I happened.
Where is that?
My lord, this is petition. But what has happened? If the transformer is not been removed, as and when the Honorable Court directed.
Sir, please go slow. I am not in very fast.
No. Leave it.
After the order of 23rd of August 2007, you made a representation.
I know.
Now the Haripal, what is the name? Haripal Rural Electric Cooperative Society is not in existence. Correct. So that order is only for the Haripal Rural Electric. So now what can be done?
My lord, today at present, there is West Bengal State Electricity Board has been taking the bill and pen. So therefore, it is a duty of the West Bengal State Electricity Board to recreate or to retransfer.
Correct.
That's why I made a representation, my lord.
When you made the representation?
My lord, that is the page 46.
46.
My lord. 23rd July 2025.
25 after 2007, 25.
No.
18 years.
What 10 years? Well,
after 18 years, 2007, the order passed by the justice.
In the meantime, my lord, my father has been died.
Maybe.
So I have been made everything, my lord.
After 2007, 25, what has happened? 18 years. Might be your child have been.
I have been waiting to.
I tell you, Lordship, kindly, my learned friend has skipped one important document. Kindly come to page 44.
Page 42.
44. But this letter has been issued by the erstwhile authority. Here in page 44 in paragraph 1, in pursuance to the directions given by the Honorable High Court, already it has been relocated, already it has been shifted to the safety measures, and safety measure has taken into consideration. In 2007, letter, kindly see the letter date 7th November 2007. That is after passing of that order.
That is it.
Let me
Advocate, not any authority concerned, my lord.
আপনি বললেন যখন আমি তো কিছু বলিনি।
না, আমি সে কথা বলছি না।
In 2007, that letter was not challenged, never challenged, and after almost, I will say 18 years, they have filed this representation. But this is unheard of. This is a court of equity, and it should be dismissed with cost.
Then, my lord, transformer is still not waited. If any untoward incident, what will be happen, my lord?
So what has happened? You have dissolved. Kindly come to the page 44, sir.
My lord, page 44, that letter written by the advocate.
Correct.
My lord, I have been reading, kindly see, Subhasis Mitra, advocate.
But kindly see, upon receiving the above notice, my client handed over the same to me.
My client
and reply
the
against the said
managing
notice.
director of the Singur Horipar Rural Electric Cooperative Society. His client.
May I place it? In terms of the order dated 23/8, yes, Lordship got that.
I have one.
But 2007, and they are sitting for 18 years.
If it is a correct, then why the honorable court or the inspection team has been not yet been detected? They have been gone to the spot and they have been saying only for
When that cooperative society left.
But in 2007, that point of time, in 2007, it has left. And thereafter, WBSEDCL has taken note of in 2008. Thereafter, subsequently, WBSEDCL.
Let them file a report. Or let them file an
After 18 years, but this should be dismissed.
No, they should file an affidavit, my lord.
The petitioner has filed the present application being CAN 1 of 2025, praying for recalling of the order dated 18th of September 2025, wherein the writ petition was dismissed for default for non-appearance of the petitioner on call. Police. Why you not appeared on that day?
Well, this, my lord. That's
where you mention.
I mentioned in paragraph 3 at page 4 of my application.
Miss the list. Police counsel for the petitioner submit that the counsel for the petitioner missed the list, due to which the learned advocate appearing for the petitioner could not appear before this court when the matter is called on 18th of September 2020. Accordingly, he prayed for recalling of the order dated 2025. Order dated 18th September 2020. And the counsel for the petitioner submit that the writ petition can be disposed of as the writ petition filed by the petitioner is barred by limitation. Police. The petitioner has argued the matter on merit and submit that initially, the petitioner has filed a writ petition before this court. Being WP number 18006 within bracket W of 2003, and the said writ petition was disposed of this court by giving a liberty to the petitioner. To file a fresh representation. To make a representation ventilating his grievances to the Secretary, Department of Power, Department of West Bengal within 10 days from date. In the event any such representation is made by the petitioner, the Secretary shall consider and dispose of the representation of the petitioner after obtaining report from the competent technical person or persons within a period of 1 month from the date of submission of such representation. It is also made clear in the said order, it was also made clear that in the event the request of the petitioner is rejected, the secretary shall pass reason and speaking order and shall communicate the same to the petitioner within a week from the date of taking. The court have also further made it clear that the court has not gone into the merit of the claim of the petitioner involved in the credit search. In compliance of the said order, the joint secretary, the principal secretary power department of Government of West Bengal has passed a reasoned and speaking order by holding that under the circumstances, I find no logic in the argument advanced by the Singur Haripal Rural Electric Cooperative Society Limited and direct the above mentioned society to immediately relocate the transformer so that the minimum statutory clearance is maintained. The work shall be carried out by the cooperative society within 30 days from the date of communication of this order. Please. In spite of the said order, the said society has not complied with the order. According, the petitioner has made further writ application before this court. Being WP number, what is the number?
WP number 14716 W of 2007.
14716 within bracket W of 2007. And this court has disposed of the said writ petition on 23rd of August 2007 by directing the respondent number 3 to depute an authorized person to carry and give an effect to the order dated 30th September 2004, preferably within a period of 4 weeks from the date of communication of the order. It is submitted by the learned counsel for the petitioner in spite of the specific order passed by this court dated 23rd of August 2007. The order has not been carried out. Accordingly, the petitioner has made representation, but till date, the order has not been carried out. In the meantime, the society, namely
Shingur, law shall find in the paragraph 2 or 3.
Namely Singur Haripal Rural Electrical Cooperative Society Limited. What has happened to the society?
This has been resolved. Thereafter, subsequently,
resolved.
It has,
and the West Bengal State Electricity Board.
Electricity Board came into force.
State Electricity Distribution Company Limited has
But this letter has been issued on behalf of Shingur.
Has taken the charge of the such society.
Yes.
Taken the charge of the such society.
In 2008.
In the year 2008. As the contention of the writ petition that now the WBSCDCL is the authority to carry out the order passed by this court, but till date, same has not been carried. Carried out according to the petition has filed the present application. Learned counsel for the, you are appearing for
WBSCDCL.
CDCL. Submit that the writ petition filed by the petitioner is barred by limitation and required to be dismissed. He has drawn the attention of this court to the communication dated 7th of November 2007, wherein the learned advocate appearing for the society informed the learned advocate for the petitioner by the said communication, which reads as follows. This one, no? Page number 44. He submits that the communication made by the learned advocate for the of the society to the learned advocate for the petitioner dated 7th of November 2007 has not been challenged. Now, after the period of 18 years, the petitioner has filed the present detail. Had the learned counsel for the respective parties produce the materials from named party full list. Get it in. This could find that the petitioner has shown sufficient cause for non-appearance before this court when the matter is taken up for hearing. Accordingly, order dated 18 September 2025 is recalled and the writ petition is restored in original file. Full. With the consent of both the parties, the writ petition is taken up for hearing on merit. After hearing counsel for the respective parties, this court find that in the year on 23 August 2007, 23rd August 2007, this court has directed the respondent number 3 to depute an authorized personnel to carry and give effect to the order dated 30th September 2004. The petitioner has suppressed the communication dated 7th of November 2007 as stated above, wherein it has been categorically informed to the advocate for the petitioner that in terms of the order dated 23rd of August 2007 passed by this court, the managing director deputed an authorized personnel from assistant engineer to this of the society to carry and give an effect to the said order dated 30th September 2004, and accordingly said assistant engineer carried out the said order dated 30th September 2004. This said communication is not under challenge, nor the petitioner has stated that the said communication is not in accordance with law and the respondent number 3 has not complied with it. Considering the above, this court find that in the year 2007 itself, the petitioner has received an information from the learned advocate for the society that the society has complied with the order and the petitioner has not challenged the said order. Now, after the period of 18 years, the petitioner has filed the present writ application, praying for the similar relief. Considering the above, this court find that the writ application that the order dated 23rd of August 2007 passed by this court has already been complied with which is reflected in the communication dated 7th November 2007. Now the petitioner has filed the present application after the period of 18 years, which is hopelessly barred by limitation. Accordingly, the petition is dismissed.
I am deeply obliged.
Get full.
Next.
I am for writ petition number 1. The last occasion my learned friend informed that one of the writ petitioner has died. He is correct. Partly correct because he said he had died in July. We took instructions. He died in October 24. So the petition number 2
how it died?
Either
October or August.
Submitted for 6 months, my learned friend. I am grateful to my learned friend, my lord.
Because your lordship also inquired what happened when you spoke to your petitioner. He said, you never inquired, I never told you. So that was the reason. Lordship, this is the case. Petition number 1 is there, Lordship. The petition can be proceeded against with, because it's a case where we have sought a direction upon the respondent 1, 2, 3 to take disciplinary action against the respondent number 4.
Disciplinary action?
Well, under the Mohammedan Marriage and Death Register Act. What had happened, Lordship, it was not actually the issue. Issue was I am also a marriage registrar under the Mohammedan Marriage Register and Death Act. He is also one, respondent number 4. I was appointed in 18. He was appointed in 2009. The dispute came to forth when he was making advertisements and promoting himself, saying that he will be giving bounty of 2 lakh whosoever will be solemnizing marriage of Sunni sect. But the act does not differentiate. The act says anybody from Sunni or Shia, marriage can be solemnized by a marriage Mohammedan registrar who is appointed by the government. So when we inquired, we came to find that he has misrepresented his date of birth as 1165 instead of 1155. So we rated the respondent number 4. So the retirement age is 68. So he represents from his school we got from RTI, Right of Information Act, that his date of birth is 1155. We also inquired further his son's birth date is in 1977. So if he is 1965, 65, So it cannot be son by 12 years at the age of, he cannot be a father and get his son admitted. So that beside the point. We made a representation to the government to inquire into it, because what has happened by December 12th, 31st December 2022, if his date of birth is 1155, he retires. So we filed it in February 23. So we made a representation through an advocate demanding justice and look into this, kindly initiate disciplinary proceedings. Otherwise, what effectively
He still is working.
Still working. Effectively, what insofar as if it is accepted as 65, he has 8 more years. I am not done that. He was promoting himself as the one who can solemnize marriage for Sunni sect only. That was the reason which led to the IR and me investigating and doing this. This is the cause. Let the government look into it and take action. That's the only cause. My learned friend says abated. Read it does not abate because one of the petitioners survives and the cause is alive. That's the only case, man.
Who is that petitioner?
Petitioner is also a marriage registrar of Lalgola, Murshidabad. He was also same.
How you maintain the writ application? How you maintain the writ application?
I am the petitioner, Lordship.
Petitioner, how you maintain the writ application? You have prayed for the co-warranto?
No, mandamus.
Then mandamus, how mandamus?
Lordship, the government.
Who are you?
I am
one of the marriage officer.
Yes, your Lordship, but the propagation, the propaganda and advertisement is doing. No, not vengeance. Lordship, I have used the word IR also in my submissions. I was nobody concerned who he was. Let him carry on. But the moment he carries on propaganda.
Writ petition challenging the appointment of the other person two way, either go in the public interest litigation or the co-warranto. How you can? You are not the affected person.
I am affected.
If you are the, how you are affected
Lordship,
person?
he is saying that he can only solemnize marriage of Sunni religion.
Not in place of you, he has not been appointed.
But Lordship, let him not propagate. He is propagating
When he
that.
was appointed?
In 2009.
And when you were
18.
Then
I was not concerned at all with his case.
Then
the moment the propagation, the advertisement came to public at large, then only I care. Otherwise, I don't have any personal vengeance against it.
Where is the publication?
Lordship, kindly. I personally don't have any agitation against him. Lordship, kindly come to page 19. 19, 20, 21, 22.
18. What is the 18? 18 is your order.
My appointment.
It's your appointment.
My appointment.
18. Then.
Still comes, sir. Now, Lordship, kindly see paragraph page 19. 2 lakh taka Puroshkar Ghoshna. Declaration as that he is MMR for Sunni Muslim.
What is this?
This is a propaganda pamphlet circulated by
the private respondent.
Yes.
Yes. Then.
And kindly 20. Here this pamphlet in crux says that only Sunni sect whosoever day I will give a bounty, but the act does not say so. It says both Sunni and Shia. I don't have any personal vengeance against him. I'm making very clear it's not a personal fight. Question is he has adverted to this practice, so I had to make investigation and comment, unearthed all this. Otherwise, I was nobody. I was 9 years junior to him. Mine is 2018, is 2009.
When you file the report. File report.
No, he is not, he is private.
I am for the private.
Yes, my lord. For this state, my lord, Mr. Nilotpal Chatterjee is appearing. Mr. Nilotpal Chatterjee is appearing. At present, he is on his legs. But if your lordship wishes to file us a report, we can come back with instruction.
No, if you want to, otherwise you want to argue on merit, I will take the matter. There is no problem. What is your stand?
No stand means, my lord, Mr. Chatterjee is briefed in this matter, my lord. At present, my lord. Then
not today.
Not today. We will come back to you.
Record an order.
Let me
my lord,
let Mr. Chatterjee come. If you have a oral instruction and you will argue the matter, then no problem.
Or my lord,
the counsel for the petition submit that. The petition number 2.
Lordship, my father.
Petition number 2 died on
28th October 24.
28th of October 2024.
Yes, your lordship.
When you file the writ application?
23, lordship, February 23.
2024. So if your father, and who is the petition number 1? Son.
Son.
So you will not substitute any other legal layer? Police. He submits that the petition number 1 is the son of the petition number 2, and he is not intending to substitute the legal for other legal heirs of the petition number 2. Accordingly, he prays for deletion of the name of the petition number 2 at the land council for the parties, as the petition number 2 died on so and so date. Accordingly, the department is directed to delete the name of the petitioner from the cost title of the writ application. Council for the respondent prays for time. Let the matter appear tomorrow.
I'll do this. Grateful.
Grateful.
Next.
My lord, item number 8, my lord, I am for the petitioner. My lord, the petitioner.
I am for the Union of India, madam.
My lord, the petitioner is a Rohingya refugee, my lord. He's a stateless person because the Myanmar Citizenship Act does not recognize Rohingya as one of the ethnicities.
My lord, same matter has already listed in Supreme Court, and it is on 16th December, my lord. Before
Supreme Court, if my lord kindly sees, this matter has been pending in Supreme Court since 2013, my lord. It was supposed to be listed in October, my lord. It has not been listed, my lord. We do not know when it will be listed.
It's already listed, my lord.
Are not
on 16th December, it is listed, my lord.
Problem is that once the matter is pending before the
No, my lord, I'll refer to a Supreme Court order only, my lord. My lord, the difficulty is that, my lord, will kindly take this judgment. My lord, in this.
My lord, same issue, and it has already listed, my lord. Before
My lord,
16th December, it had hard, could not be hard, my lord.
Allowed to make my submission.
It has already listed. Okay, my lord.
I will hear. Yes.
If my lord will kindly see, my lord, this is division bench of Supreme Court, my lord. Justice J.B. Padriwala and Justice R. Mahadevan's judgment, my lord. My lord will kindly come to paragraph number 17, my lord. That is at page 15, internal page 15 of the judgment, my lord.
Yes.
Yes. My lord will see. We are of the view that if there is any illegal immigrant as on date in any of the prisons within the state of West Bengal who has undergone the entire sentence and is still confined in any of the prisons past 3 years from the date of completion of his or her original sentence, he or she shall be released on bail subject to the following conditions. Execution of bond, my lord. Sureties of rupees 1 lakh each of Indian citizens. He or she specifies variable address of stay after release, biometric of his or her iris if possible, and all 10 fingerprints and photos shall be captured and stored in a secure database before release from the detention center. He or she shall report once every week to the police station specified by the foreigners tribunal. He or she shall notify any change of his or her address to the specified police station on the same day, and a quarterly report to be submitted by the superintendent of police to the foreigners tribunal regarding appearance of such release declared foreigner to concerned police station. And in case of violation of condition, the DFN will be apprehended and produced before foreigners tribunal. The authority concerned shall undertake the necessary exercise to identify all such illegal immigrants who are still confined in different prisons. My lord, I fall squarely under this order, my lord. My lord, the difficulty is that if my lord will kindly see paragraph number 22 and 23, this case has now been transferred to 3-judge bench.
Correct.
And now we do not know when it will be heard, my lord. Supreme Court has
It has already
granted
listed, my lord.
bail. My lord, the only
It has already
difficulty
listed.
is that, my lord, if I may be allowed to go, my lord, the only difficulty in this order is that it has specified foreigners tribunal, and now there is no foreigners tribunal in West Bengal. That's why this person is still rotting in jail, my lord. Even though there is no law on the land that can continue holding a person after they have served out their sentence. Well, at 8 years, 8 months, he has completed his sentence in April 2017, my lord. They're still being held under what law, my lord? This petition was filed 1 year, my lord. Date after, my lord, we do not know. I have also handed over to your lordship the case status. My lord will kindly take that. My lord will see since when this matter is pending. And my lord will also see. It was supposed to be listed on October. It was not listed, my lord. We never know when it will be listed.
Sent to Supreme Court, my lord.
My lord, if it will be listed after 10 years, my lord, should this person continue to be in jail for another 10 years? My lord, these are Rohingya refugees, my lord. They have UNHCR card, my lord. They have recognized by the United Nations. They flew their country out of fear of persecution because there is a genocide going on. There is a case going on in International Court of Justice, my lord. Gambia versus Myanmar. These are not illegal immigrants or economic migrants. They cannot be looked at through the same lens. And there are Rohingya refugee camps in Delhi, my lord. There cannot be a class within a class. The union cannot keep few Rohingyas inside the jail and house others in refugee camps.
Yes.
My lord, it is already pending. Same cause
What
of
will happen pending? It's okay. What
but,
will happen?
and it has already listed on 16 December, my lord.
Tell me the answer to the query first, then you made a submission.
Okay, my lord.
What
Sorry.
will happen to the order passed by the Supreme Court wherein certain direction is being passed? What will happen? Okay, 3 judges bench. 3 judges, there is no that till that the order is to be remain state where show me the order. The order of the division bench of the Supreme Court is stayed by this the full bench. It is hearing what is to be done. So what will happen once the division bench order is staring in the face of the record and before this court? This court is binding. The order is binding upon this court. What will happen? Tell me.
In that situation, I have to get the instruction, my lord.
What instruction? The matter is listed for the last several days. Only because it is pending. So the state has to take some action. Whatever, if anything, the court is not telling that he may be sent. There's no order for sending or any deported to their country.
Released on bail, my lord.
So what will happen if it conviction and what will happen to the order of the division bench of the Supreme Court? A clear cut direction has 5 points have been given.
In the present era, it is a very vital issue, my lord.
Okay, I will record you. You have restrained this court to pass any order, and you will take the responsibility before the Supreme Court.
Oh,
and I will send the matter to the Supreme Court. This is the attitude of the Union of India.
No, my lord.
Then tell me, give the suggestion.
In this respect, I have to take instruction, and because along with me, our senior counsel is also here.
So the matter is listed.
2 days adjournment, my lord.
Why last
5 adjournments.
Last occasion also you have taken
5 adjournments.
Last occasion, I
before this court, before me, this is the fourth time or fifth time. When I was treated other court, twice the matter was taken. Now before this court, 3 times.
Today is my at least it is my humble prayer, my lord.
You have a knowledge with regard to the pendency before the larger bench, but you have no knowledge. What about the order of the division bench? What is to be done? Whether it is nullity if the pending before the larger bench.
Then please give me a little password. I asked my senior counsel to come.
Yes, sir. State.
My lord, may I respectfully invite your lordship to some of the orders passed in this matter. Lordship, may your lordship take up the bunch of the order sheets. Order dated 8th April, my lord, 2025. Kindly text, my lord, the order dated 8th April, 2025.
Yes.
Learned counsel for the Union of India submits that he is yet to receive instruction from his client.
Correct.
Stand of the Union of India is very much required to be taken into consideration for passing any order directing sending the petitioner to UNHRC in Delhi, where he may be united with his family members. Learned counsel for the state, that is me, relies upon a particular various orders by various fora, including the order passed on the Supreme Court in Salimullah, 2020 and 19. Learned counsel for the Union of India is directed to revert with written instructions released. So, my lord, the Union of India has to come with a written instruction.
Correct. That's what I'm telling.
And, my lord, thereafter kindly sees, my lord, a minute. Kindly sees, my lord, the order dated 20th May 2025. Mr. Banerjee appeared for the Union of India, Mr. Athuru Banerjee and Shubhit Majumdar. What was the order? Learned advocate representing Union of India prays for adjournment. It has been submitted. The issue relates to status of the Rohingyas.
20th May also, you have not produced the order of the 16th May of the Supreme Court.
Because it was not uploaded, my lord, by then. That's why there was an
Not even informed. Okay, whatever it is. Then
Now, Miller, kindly see next order sheet, 5th August 2025.
yes.
Matter relate to Rohingya victim. Para 2, learned counsel for the petitioner relies upon an order dated 16 May 2025, passed by the Honorable Supreme Court in case of so-and-so, based on which she prays release. Para 3, learned counsel for the Union of India. 2 relies upon a judgment of the Honorable Supreme Court, Zafarullah so-and-so, along with a bunch of writ petitions relating to issue of release of Rohingyas. The matter has been made returnable in the month of September. As the issue in the instant writ petition is more or less similar to the matters pending consideration before the Honorable Supreme Court, accordingly, hearing of the instant writ petition stands adjourned till November 4, 2025. Parties are directed to bring on record so-and-so, all parties to us. So, my lord, written instruction was the direction, my
Yes,
lord.
what is the written instruction?
I had already mailed before that person.
Hey, Mr. Banerjee has come.
Yes, where is the written instruction?
First of all, my lord, with regard to the enlargement of bail, is not an in rem. It's in personam. But the issue, in a great sense, it has been referred to the larger bench. And the larger bench is insisting. It is to be taken up on 16th December. But if your lordship kindly takes up this matter, my lord, after 16th December, any date.
Where is your written instruction?
Yes, my lord, I'm giving. কোথায় তোমাকে যে
Where is
ইনফরমেশনটা
the written instruction?
Yes, I'm giving.
Information given.
But information already we have submitted, and last occasion also we have submitted before the court. I believe, my lord, it is kept with the record. No, report now.
No report, only Supreme Court judgment.
Yes, my lord, that is there. Subsequently, my lord, the information slip I have also filed. Just today, my lord, I have handed over. It indicates.
That is correct. My only simple question is that if the matter is before the larger bench,
my lord,
whether the larger bench has put the stay on the order passed by the division bench, which is in a reference before the larger bench.
Yes, my lord, the first issue.
Yes.
First
Whether
issue.
there is an order of the stay.
My lord, I have to take the formal report. No,
because now this court
is not binding upon. Then, my lord,
not binding upon the binding upon the division bench order where
exactly.
the category direction has been passed.
My lord, I have to take the
Lord, there is no stay because the matter has not been listed.
Only one data.
Decorum is to be maintained.
Absolutely.
Then,
my lord, I have to take only one day. I require. My lord, let it be not today. My lord, I will come tomorrow.
every time you are taking time.
No, my lord, last 3 occasions, my lord, we have submitted before the court.
My lord, 5
the order passed by the
occasions.
Supreme Court time to time.
My lord, it was the petition. It was me who had submitted the Supreme Court order. My lord, kindly see the last 5 orders, my lord. The union has taken time to file written instruction, my lord. On the first day itself, the union was asked to submit a report with regard.
That Mr. Respondent has pointed out.
Every single day, my lord. My lord, the order is not stated. Moreover, my lord, that division bench was, that matter was referred to larger bench to be tagged along with other Rohingya matters, my lord. And there has been no hearing since then. So there is no question of stay on that division bench order, my lord. And even then, it is showing that tentative computer generated date. My lord, the next date scheduled was October. It was not listed in October. We do not know if it will be listed in December also, my lord. It might take years for the hearing. This is pending since
He has to file
2013.
an application under section 439.
For what?
My lord, for enlargement of bail.
How can a bail be granted to someone who has already completed sentencing, my lord, by the under 439, my lord? The CRPC has no such provision for
Then,
that.
my lord, he has to go before the in detention center under the Foreigners Act.
That's why I'm asking. See, if a foreign national sentence completed, provision of bail is not there, jail authority has to release, then the civil authority has to take care and to send to the detention area.
That is the issue, my lord, is completely pending before the Supreme Court, that whether they will be pushed back or they will be in the detention center. That is the only 2 points.
And pending that issue, my lord, they were released on bail. It is written, my lord, kindly see this language that has been used by Supreme Court. He or she be released on bail.
A convict who has already completed
Completed,
sentence.
then
how
my
the
lord, he
case
has to,
lies.
Well, the
then he has
Supreme
to be
Court, my lord,
released.
kindly.
Convict
Even if he is
who has
released,
already
where he will go?
completed sentence. And the conviction was with regard to section 14 of Foreigners Act, staying beyond the visa
Beyond the
period.
period of the visa.
So if he is released today, then
Then
the
where he
position
will go?
save.
Correct. That's why. No, that's
So
why.
what we do, we are having a separate section.
Correct. Civil authority. Yes, civil authorities are having a separate area.
Section.
So they will not allow to
Jail
go
is
out.
jail.
They are not. They will not allow to go out.
Exactly, they will be in a
They will
detention
taken from
center.
the jail and will put in the other places.
That
and
is detention
restriction order
center.
will be passed. They will not go this is
Beyond that.
beyond area, and they have to every evening and morning there will be a roll call. This is the procedure.
My lord, may I rely on certain judgment, my lord? Supreme Court's division bench judgment, my lord?
But kindly come to the passed in the Jafarullah order dated
My lord, the pre-judgment.
31st of July. Jafarullah order dated 31st of July.
Yes, your lordship.
Got it? Just a minute.
Issue of release of Rohingyas.
No, for that time there is no printer is not there. Only I want the printer. No, only simple printer. But the printer is not working. Printer is working. Okay, I will see. Yes.
Yes, your lordship.
So kindly come to that order. You have
Yes, your lordship, I have.
page number 12.
Yes, your lordship.
Page number 12.
It has been categorized in 3 groups, my lord.
Yes, 3 groups.
Yes,
If
your
the Rohingyas are not refugees, even the Rohingyas have been held illegal errand can be detained indefinitely on release on bail. Whether the Rohingyas who have been deported, detained, if the Rohingyas are illegal errand, whether the so and so. Yes, where is the issue? In that, there is no issue if the Rohingyas has completed the sentence. What would
No,
be
my lord, here, whether the Rohingyas are entitled to be declared as refugees, number one.
That is different thing.
Now, next, my lord, if so, protection, privileges or rights are they entitled to? Now, if the Rohingyas are not refugees and are illegal, my lord, entrants, whether the action of the union and states is deporting them is justified. Even if the Rohingyas have been held to be illegal entrants, can they be detained indefinitely, or are they entitled to be released, or are they entitled to be released on bail subject to such terms and conditions as the court may deem fit to impose? And whether the Rohingyas, my lord, this is I am giving emphasis on that.
No, Rohingyas refugee. No, kindly come III.
II
If the Rohingyas have been held to be illegal errand.
Yes, in case they are illegal, they are held to be
entitled
illegal
to be
entrance.
released on bail subject to such terms.
Can they detain indefinitely and they are entitled to release? Because here, whether they have been, the conviction is passed or not. It is not.
It is not that case.
This is not. This is
Therefore, under
the
trial.
pendency.
Under trial.
Yes, they
Under
have
trial.
held
What about the completion of the trial? Once the trial judge has held, yes, she
Yes,
found guilty.
conviction
And
when
2
the
years.
now, my lord, now this, my lord, if your lordship kindly sees that, my lord, whether now Rohingyas are entitled to be declared as refugees. Now, first question, my lord. Suppose, my lord, conviction complete.
Court is not going to that. The Supreme Court. Only my question is that once the person has completed his tenure in the custody, in the correctional home, after
Conviction
the
complete.
judgment completed, what would be the
He has to be released. Number one, he has to be released. Now, my lord, what will be his appropriate status?
That's I'm telling. That is the civil authority has to take the custody.
For such reason, my lord, Supreme Court has specifically indicated whether the Rohingyas are entitled to be declared as refugees. Now, my lord, if
refugees different things, refugees some different thing. If leave aside the refugees, if any foreign nationals
my lord
have been convicted,
my lord,
Thereafter, he is released.
No,
Sentence
sentence
completed.
completed. The
Completed.
jail authority will not continue to allow. Immediately, civil authority will take and put in the civil authority
Detention center.
detention area, and unless and until then the Home Ministry will make a correspondence with the other ministry so that they can be
Now, my lord,
But
this-
here, what will happen? Here it's this is not asking for the declaration of refugee. What will happen to that? Because why
Conviction completed.
yes, why the division bench has passed an order? Because we find the court find there is so many persons are detained in the custody. That's why with the court is granting the bail so that the some population should be reduced from the custody.
Exactly.
Jail inmate, population.
Population.
Jail population.
Your population is increasing, and if you are telling that the conviction is completed, but they should remain in the custody.
No, that is not the law. That cannot be the law.
May I
please take that on this point only. You
Only.
take instruction specifically from the government and come day after tomorrow.
Yes,
and fixing
my lord, this is also a very important thing, lord. If your lordship kindly sees one IV, whether Rohingyas who have not been deported or detained but living in refugee camps have been provided the basic amenities like sanitation, drinking water, education, on other living conditions in conformity with the Article 21 of the Constitution of India. Now the issue remains, the state has to assure that.
Correct.
The union cannot deny that there is a Rohingya refugee camp, my lord.
Again, the point will raise. The person who is in custody and is under trial, not been granted the bail. The state, not only the food, every day 27 rupees or something is to be
Exactly.
paid, which they are working.
Exactly. Article 21 applies on both the cases, both sides.
Persons who are under trial, facing the trial, are in the custody, and they have been deputed some work.
Exactly.
Or handicraft work, whatever it is, every day they have to pay the amount also.
Exactly.
Other than the food.
Now, the state has to assure that whether this thing is there or not. If it is there, he will be there.
That's why the state is telling that if you say we allowed to take, because jail authority.
Refugee camps for Rohingyas are not in
I
the
don't-
state, it is in Delhi.
That's in Hyderabad, my lord.
It is only in Delhi and Hyderabad.
The union
Total
cannot
Rohingya
refuse
camps
that there is a Rohingya refugee camp. The union is housing them, my lord. How can there be a class within a class?
Day after tomorrow?
My lord, day after tomorrow, a similar matter is there, my lord. If that can be tagged together, my lord.
The for the Union of India.
WPA 918.
Take instructions. Take specific instructions whether the instruction to the effect that the petitioner has already completed his conviction in the correctional home, comma, whether the petitioner can detain in the correctional home or he will be released and be taken into the by the civil authority, or will be taken by the civil authority. Let as per the prayer made by the Council for the Union of India, the case is adjourned. Let the matter appear on 26th.
Release the Hoyner, civil authority.
My lord, the similar matter may be tagged together, my lord. WPA 9182. That is also fixed on 26. And so may I indicate, my lord, there is no detention center, my lord, in West Bengal, my lord. It came up in question in another matter.
Delhi and Hyderabad.
My lord, the Rohingya refugee camp is in Delhi and Hyderabad.
I think it is every state.
It is coordinated by the United Nations office.
Yes, your lordship, the UNHCR.
No, there is a provision. Every state has to make
a detention center.
My lord, that has not been made.
Different aspect.
My lord, that has not been.
In the order sheet, it is there. In the order dated 8th April. The stand of the union is very much required to be taken into consideration for passing the order, directing sending the petitioner to United Nations UNHCR camp in Delhi.
Well, because a similar order has been passed by our High Court and as well as Division Bench of the Punjab and Haryana High Court, where these Rohingya refugees have been handed over to the UNHCR so that they can be reunited with their family members living in Rohingya refugees.
Their fate is decided, they have to be considered in a particular place.
Yes,
not in the correctional home. Not in the
Exactly, my
correctional home. You keep anywhere, but why in the correctional home?
My lord,
He was the authority will report to Delhi refugee camp.
Yes, Delhi or Hyderabad, whatever it may be. Okay.
Great.
I will get.
Yeah. Item number
40. 40.
से ना जो इस जो फिक्स मैटर होएगा ना टाइमली उसको ऊपर दे दो स्पेशली फिक्स मैटर ठीक है हाँ पर
All other matters will release after
which one no I will take the matter after this I will take continue
একটুকুনি
I appear for the point number 6, my lord.
who is for the petitioner
Advocate Devajyoti Basu
Ah.
for the petition.
Ah.
He's coming from.
Huh?
He's coming from 551. If others starts.
what is the matter
What is the matter? The matter where my lord, the petitioner seeks my lord, and direction from this honorable court, and your lordship may comes kindly to my lord, page 21 of the petition, my lord. And she seeks my lord setting aside of an impugned letter, which your lordship would find my lord at page my lord 40. No, not 40, my lord, my mistake. Page 43.
no, yes challenge the 31st of July
Yes, at
31st
page
of July
43, my
page 40
43.
43
And she's a counselor.
Appointing letter.
Your lordship, kindly see the appointment letter whether the read.
directed to report you
Yes.
39.
My lord, may kindly look into page 39, the appointment letter, and whether the writ petition itself is maintainable, my lord, before your lordship.
39
Yes.
39, Lord.
yes
Now may I place, my lord? Clause 1.
the appointment is purely temporary continuation project W honorarium sensation 25 days
Clause 2. No salary, only honorarium.
honorarium
So, my lord, how can a writ petition be maintainable?
what is the writ petition
Okay, my lord,
July,
senior
what is-
friend is there to apply.
May it please the lordship, I'm sorry, my lord, for I'm a minute late, my lord.
yes
My lord,
what your challenge sir
my lord, my challenge is, my lord, so far my the letter issued by my lord, the Lal Bazar Police Headquarters, whereby my lord, by the said letter, my lord, a stroke of pen, I was directed, my lord, that my employment in the Lal Bazar Police, my lord, at for the as a purpose of a counselor, my lord, shall be my lord, cease to effect, my lord, with immediate from the date of the appointment, from the date of the letter. And my lord, all the staffs which were provided to me, my lord, are being withdrawn. This page 43, my lord, is under challenge. Now, my lord, before your lordship takes up this, my lord, may I just take your lordship, my lord, to a very, my lord, a short, brief facts of this case. Sometimes, my lord, in the year 1990 to 93, Central Social Welfare Board, my lord, in its their wisdom, I stand corrected, my lord, 1988, my lord, to form my lord, counseling center throughout my lord, the country. And my lord, it is to be funded by the Central Social Welfare Board, a unit of a Union of India. Lordship may kindly find the same thing, my lord, at page 25. Kindly comes, my lord. Yeah, take it. Now, my lord, here, the purpose, my lord, to see the person aggrieved, my lord, comes within the definition under my lord, Domestic Violation Act. That, my lord, those who are aggrieved person, my lord, may be, my lord, so far, my lord, they may be given proper counseling for the purpose of redressal of their grievances. Now, my lord, on the basis of this, if your lordship kindly takes up, my lord, page 26, there is a project scheme for setting up. Now, my lord, what are the projects? That scheme for setting up, your lordship will be pleased to find at page 27. Kindly, my lord, have a look. That what are the project at the scheme project, my lord, that was set up by the Central Social Welfare Board. Has the lordship found, my lord, page 27?
scheme for setting up counseling center in police department, kindly underline below, at all state capitals. Now, my lord, the fourth line in the first paragraph on the right side, who are victims of atrocities and exploitation. Lordship has found, my lord. First paragraph, fourth line, right side. Who are victims of atrocities and exploitation. Well, I am only showing the bare things, my lord, which are necessary for my lord's judicial consideration. Now, my lord, kindly takes up next page. Page 28. What are the objectives? Now, my lord, the objective of the counseling center in the police headquarters will be followed. Now, my lord, there are several objectives, my lord, I stress on column Roman small 3. To conduct independent inquiries and submit reports.
Where from here reading?
My lord, page 28. Lordship has seen page 27.
27, yes.
Lordship, my lord, at the first, my lord, I showed page 25, how it was formed by the my lord, Ministry of Human Resource Development and Department, my lord, of Women and Child Development. Now, my lord, on the basis of this 1988 notification, my lord, there was subsequently, my lord, 1998 Central Social Welfare Board, my lord, issued letter to all state boards along with a project scheme.
Correct.
That, my lord, project scheme, my lord, is a part of the letter of page 26, which will be followed from page 27 onwards. Lordship has possibly already looked into page 27, scheme for setting up counseling centers. The main purpose were the victims of atrocities and exploitation. First paragraph, fourth line, right side. Now, my lord, kindly turn to now, my lord, next page, page 28. Objectives.
Yes.
The objectives of the counseling center in the police headquarters will be followed. There are, my lord, several objectives for which the counseling centers are being formed. Kindly, my lord, for the purpose of this matter, my lord, in the facts of this case, kindly see Roman small 3.
Yes.
To conduct, I'm sorry, my lord, independent inquiries and submit report to Women's Cell and reported cases of indifferent or negligent attitude of police in the cases relating to atrocities and violence against women. So, my lord, it is not something limited. It is only for the agreed person. I was also there to see how the cases are being handled by the police personnel and whether, my lord, something indifferent attitude are being shown or not. Now, my lord, how these expenditures are being borne, kindly see the same page, expenditures.
Yes.
This is a project, my lord, funded by the central government.
Yes.
Now, these expenditures, my lord, on the same page, these pilot projects would be funded by the Central Social Welfare Board. Now, my lord, skip over 3-4 lines. The state board will also be the responsible for handling the funds. Lordship has seen, my lord. So, my salary and everything, when I was appointed by the state board on behalf of the central board. Now, kindly see the next page. Page 29. Note. The counselor, this is a part of expenditure, the counselor of the center will be given fixed monthly honorarium. It is also proposed to provide conveyance, etc., that the counselor may for the mobile car intervene in a case such and such. Now, my lord, how do I function? Function is, my lord, is very important. Counselor in charge and the counselor shall perform the following functions: registration of cases, investigation through personal contact / correspondence, recording of interview, home visit, etc. Then 2, providing counseling guidance to the women concerned and also to the family members. Now, 3-4 are not very important. Kindly see the next paragraph. The counselor in charge will be overall in charge of the counseling center and would report to the DCP/SP. She would be informed of all the cases registered in the center and the action taken on them. And DCP also guide the counselor as and when necessary. She would be also responsible for sending half-yearly progress such and such. Now, my lord, these are the objectives and how it was formed. Now, my lord, kindly turns to now next. My lord, page 32. Well, basically, it's a part of page 31, the government notification pursuant to the central government directions. Is a page 32, Millard, bottom left side. This is how, Millard, it's being notified in the Gazette. Yes. This has been done, Millard, sometimes in, Millard, if I stand corrected, Millard, in 94. This part 4, Lordship has seen, my lord, part 4 miscellaneous notice. Department of Social Welfare, Women and Children has set up 2 family counseling centers at Lal Bazar. My case is with Lal Bazar because I was there, my lord, since 1995. And 34 Park Street to deal with cases of family dispute and domestic violence. Now, my lord, what are the address? Kindly see, my lord, next 1-2 Lal Bazar, headquarters of police, 18 Lal Bazar. So this has been, my lord, my consistent address since from the beginning. On the same basis, my lord, page 33, your lordship will be pleased to find that there is a detective department website, my lord, where detective department said, my lord, at the bottom of that page that we are setting up this counseling center, etc., etc. Now, my lord, kindly straightway turns to page 38. My lord, on the basis of this, my lord, central government directions and, my lord, for the funding, my lord, there is a state welfare notifications board. Now, my lord, kindly see page 38. It was written by the West Bengal Social Welfare Advisory Board, Bhavani Bhavan, etc., to the petitioner. It was in respect of interview for the post of family counselor at police headquarters, Kolkata. It was dated 15th May. In response to your application that is such and such, you were directed to appear such and such and such and such. Now, this is my interview letter. Not very important, but this is only important, how I was appointed, the process of selections. Now, let's see my appointment letter at the very next page, page 39.
Yes.
This is important because this ultimately my entire case would be boiled down from this. The Sri such and such is hereby appointed as a councillor at FCC at police headquarters under the innovating project of CSWB and direct administrative, kindly underline this, direct administrative control. My appointing authority was West Bengal Social Welfare Board and I was terminated by police personally. This would be a point of argument, my lord. Direct administrative control of West Bengal Social Welfare Board, Bhavani Bhavan, Alipur, such and such. The appointment is purely temporary. The continuation of the project, such and such. Now, my lord, kindly see the 5, which is very important, my lord. The appointment may be terminated at any time by 1 month notice. Lordship has seen, my lord, yes. Serial 5. From either side without assigning any reason thereof. Now, my lord, I would be, my lord, stressing, my lord, I will be developing 2 points of argument, my lord, that there is a stipulation of 1 month notice. So I can be terminated with immediate effect. Number 1. Number 2, even in case of a temporary or contractual employee, even if you say that without assigning reason, but something when, my lord, a stigma is there, some allegations are there, my lord, you are, my lord, authoritatively duty bound to give me a hearing and prior to that show cause. Nothing was done. Now, my lord, after this page 39, my lord, kindly see, my lord, since 1995, I had been working there, page 41 and 42. There are various other appreciations, my lord, under whom, my lord, are the DCP of the crime branch, my lord, page 41 and 42. I was given, my lord, letter of appreciations. I do not, my lord, trouble in reading. Lordship, my lord, is quite fast enough. Let me, my lord, kindly see page 41 and 42. These are the 2 letters, my lord, written by the concerned highest police officers, my lord, giving my appreciation of service. I would only read the first paragraph.
Okay, no problem.
No problem. Now, kindly see after 41, all on a sudden, page 43, your lordship had been already seen, my lord, that who had issued reserve officer, kindly comes to page 43. Reserve officer DD, that is detective department, Kolkata. It was written to me. Now, my lord, kindly see how I was addressed.
This is an impugn order.
Impugn order. Now, my lord, kindly see. Srimati Shormishta Rai Chaudhuri, Councillor, Family Counseling Detective Department, Lal Bazar, Kolkata. Now, I'll also put it a mark. Their allegation is this. I write my address saying that I am at Lal Bazar. They have given them me as a, addressing me at Lal Bazar. My posting is at Lal Bazar. I sit at Lal Bazar.
To report your concern.
Exactly. I mean, as directed to report to your concerned authority from DD Kolkata with immediate effect.
DD Kolkata means?
Detective Department, Kolkata. That was a reserve officer, also DD Kolkata. Reserve officer is under the Deputy Commissioner, is under the IPS. And your lordship would be pleased to see, the right side top of that letter, Detective Department.
Correct.
So, as directed to report to a concerned authority from DD Kolkata with immediate effect, and also inform to you that supporting staffs of your office of DD are hereby returned and report to Reserve Office DD immediately. Now, my lord, after this letter, my lord, I have given representation at page 45 to the Joint Commissioner Police Crime, saying that this is something, my lord, an unduly attempt, my lord, an arbitrary attempt. My lord, I tried to request, my lord, the issues, my lord, there has been nothing wrong. There was no show cause. Why all of a sudden, my lord, contrary? And when West Bengal Social Welfare Board, my lord, did not issue a show cause, I also issued letter at page 45. And also,
at present, you are.
I am not there. I am not.
Before this order,
Lord,
before this,
I was there since 1995.
correct. Before this order, you are in the Lal Bazaar.
Lal Bazaar.
Correct.
Lal, my
You
lord.
are in the Lal Bazaar and submitting the report.
Lordship.
In 2023, you have been directed to report to the detective department.
No, my lord.
Authority.
I have been
report
as directed to a concert from DD with immediate effect. So my power has been seized off. This is, my lord, this is meant.
Director, report your concerned authority from
Yes, and inform to you that supporting staff of office are hereby returned.
return.
So that means, my lord, my job, my lord, cease to effect has come to an end.
Okay.
And whatever the staff, my lord, what are the staffs? Is a home guard, lady staff, police officer, because it's a women counseling center, and my lord, lady constables, my lord, all are being taken off.
Correct.
This is, my lord, how a language, my lord, that they are being issued. Now, my lord, I also thereafter, my lord, I gave representation at page 45 to the Joint Commissioner Crime, Detective Department, Lal Bazaar. I also, my lord, requested, my lord, to my appointing authority, my lord, at page 48 and 49, my lord, water, my lord, that this is something, my lord, comes, my lord, out of hot and, my lord, out of blue, my lord, where, my lord, I was, my lord, at no point of time, my lord, this, my lord, could have been at all done. Now, my lord, on the basis of this, my lord, in pendency of this writ petition, I also, my lord, I have taken out 2 supplementary affidavits which are in my lord's brief. My lord, kindly look into, my lord, the supplementary affidavit, my lord, affirmed in August 2023.
Yes.
My lord, in pendency of this writ petition, some, my lord, facts which are, my lord, interlinked, kindly comes to, my lord. It is, my lord, my prime duty to bring those facts as a, my lord, is a court of record. My lord, kindly see page 9. Is a letter of the West Bengal Social Welfare Board dated 14th August. Lordship has seen, my lord.
Page 9.
Page 9 of the supplementary affidavit affirmed in August 2023.
No, that August 2023.
Yes, my lord.
Page 9. That is page 9 is the your averments are there. September that is a September.
Lordship is looking into, my lord, August 23 or August 25.
August 20, which you are referring the page 9.
9 is of August 23.
No, August 23, page 9 is the averments. Page 9 are the averments. Not your any annex.
Page 9.
Well, what's possibly Lordship looking into the other affidavit, which is affirmed in August 25.
Correct.
I am saying, my lord, August 2023. There are 2 affidavits affirmed in the same month, but 2 different years.
Page
9, my lord.
Yes.
Was a letter of West Bengal Social Welfare Board.
Yes.
Lordship has seen, my lord.
Yes.
Page 9, letter dated 14th August 2023.
Yes.
Well, kindly see second paragraph. Now, also first paragraph. With reference to the subject I have cited above, this is to inform that a serious allegation for the first time, I was terminated. Then, my lord, they thought it, my lord, prudent to inform me a serious allegation has been leveled on Mrs. Such and Such, Councillor of Forum of Social Action, who is rendering services to the police headquarters. As report to the Kolkata Police Department, there have been numerous complaints against Mrs. Rai Chaudhary, like threatening, pressuring the clients, demanding money from the complainant. A writ petition being WPA 10506 of 2021 had been filed by the agreed party, alleging her misconduct before the High Court against her, where Kolkata Police was also a party. It is also alleged that the Mrs. Rai Chaudhuri uses the name of Detective Department, Kolkata Police, to create a false impression in the mind of the general public that she is a part of Detective Department. Now, Lordship has seen the letter they issued themselves. Now, this writ petition, I have annexed this order. Kindly see by a coordinate bench at page 12. This has been something anonymous allegations, but it came as an afterthought. I was never given show cause. Page 12, this is the same writ petition. Kindly see the first paragraph. Lordship has seen page 12. The petitioners complained that they were not heard before the authority taking action, taking decisions. Where the complaint against me? On the light of this, then what the state submit? That the allegations of not hearing the petitioner are without basis, the petitioner were issued notices and they choose not to appear. Did the state say, appear and submit to this court that yes, this was because of Mr. Rai Chaudhuri? This was the foundation which has no basis. Kindly see 2 pages order by Justice Boshe, the coordinate bench, where my name is being reflected and why I am being put into this guillotine.
No, this writ petition is filed by
Another somebody person.
Correct.
Allegation is this writ petition, since Kolkata police was a party, so you have a responsible person, there are allegations in the writ petition against you.
Correct.
Now, how the allegations are being, is there any allegation? This is a court's order, this is a matter of record. And the petitioner's allegation is recorded in the first paragraph. And the state recorded, what are the submission on behalf of the police? They say that the allegations are without any basis. The allegation of the petitioner were not being heard is something wrong. They were issued notice, they choose not to appear. So this is the their case, I am only trying to show the what were the actual case, and how I am being implicated. Now, next after page this 9, and this order, kindly see page 15 in the same supplementary affidavit. This is my identity card, how it was issued and who had issued. This is also, they say, we have to check and find out who had issued this. They could not even dispute. They say, why I am using this? This is the thing, because you have issued to me. What is written there? Okay, designation counselor.
So what is the next?
Now, the next thing is, kindly, take up my next supplementary affidavit affirmed in August 2025.
Yes. Yes, next.
Here, kindly see, I have also given a direction, which have been given to the all state boards at page 16 and 17 to show, how a councillor is to operate. I will only show, 2 things, page 16, column 2 at the bottom. Page 16, column 2 at the bottom.
Yes.
There should also be proper coordination and liaison between the FCC in the capital as well as in the star cases requiring police interventions may be referred as FCC run by the volunteer organization to the FCC at police headquarters. Now, turn to the next page. Roman 3. In all reported cases of indifferent, biased, negligent attitude of the police, in cases relating to atrocities of women, dowry rates, etc., an independent inquiry must be conducted either by FCC run by voluntary organization or in the police headquarters. A via media may be evolved in consultations with the Commissioner / Director General of Police to ensure their safety and avoid harassment of the councillors. Kindly underline by the defaulting policemen. Yes. I could say, I am now being harassed because 1995, 2023, there has been no allegations of IATA without any demeanor, for almost 28 years, starting from my age at 30.
What has happened after the order?
After this order,
after the order passed by this court in the writ petition of the other persons, what has happened?
My lord, they were given hearing.
Then
They were given hearing, and my lord, the case was never reopened further. Nothing has come from. Now, my lord, I would also like to show, my lord, their report filed pursuant to the directions of a earlier, my lord, coordinate bench. Kindly comes to the report. Lordship is well aware, my lord, something which was not there, you cannot develop it by way of a supplementary affidavit.
where is the report?
My lord, report is in my lord's record, my lord. On the last occasions, my lord, before possibly Justice Sinha, my lord, the report was filed. And pursuant to my honorable court directions, a copy was also handed over to me. So I have to first make out my case, my lord, on the basis of my writ petition that I have shown, my lord. Number one, my lord, there was the violation of the stipulations, my lord, given in my appointment letter, my lord. There's a 1 month notice that was not followed. Secondly, there has been a stigma. So even if a temporary employee, my lord, I must be given show cause, an opportunity of hearing must be given. That was not given. Lordship has found, my lord, the report.
Yes.
I'm grateful. Is a 5 pages report, my lord. The petition, my lord, kindly see second paragraph. The petitioner such and such had been the counselor in charge of Family Counseling Center. The State Family Counseling Center was set up by West Bengal Social Welfare Advisory Board, which works under the Department of Women, Child Development, Social Welfare, Government of Bengal. In the year 1995, West Bengal Social Welfare Advisory Board posted several counselors, including Shormishta, to work at Family Counselor Center situated at Lalbazar, Park Street, Bhavani Bhavan. In the year 1999, such administrative controls, kindly comes to the next page. Now, next page, second paragraph. It will be pertinent to detail here that since last few years, so you have, according to them, since last few years, but still then, my lord, they accepted me. Then there was no complaint. Several complaints from different individuals were being received at this department, wherein those individuals made allegation against Shormishta that in the name of counseling, she was harassing them, criminally intimidating them, to implicate in criminal cases and pressurizing them to withdraw the cases registered at police station or before learned court, and also demanding a lump sum amount of money as bribe to settle a matter. Now, very important. After conducting an inquiry, how did you conduct? I was never given a party to this. On certain complaint, I was not made over to any complaint. It was revealed that Ms. Shormishta used to receive complaint from the aggrieved directly. The notification authorized me to receive complaint directly, and also by the police who was being referred by post or by email. Those complaints were not endorsed to her by any senior officer of Kolkata Police for the purpose of conducting counseling. Now, my lord, skip over 3-4 lines. Now see the notices start with, further in such notices, she used a rubber stamp. What she was saying, my lord? Having impression counselor in charge, Family Counseling Section, Detective Department, Lalbazar, Kolkata 1. This is the allegation. Well, what do I write? Address at footpath. Yes. I was sitting there. Yes, the same was creating a misconception in the mind of the general police that the said counselor in charge was a member of Kolkata Police Force entitled to arrange such hearing and further direct solutions. Now, during such counseling sessions, she would represent herself as having the authority to conduct search and seizure like any police personnel, and as such, she take all possible action based on the letter of complaint submitted by an aggrieved party. It also revealed that in some matters where criminal cases or civil cases are pending between the aggrieved woman and the opposite party, she would often intervene into the matter in an extra-legal way. In the past, owing to her such activity and behavior, a writ petition, kindly underline, my lord, 10506 of 2021 had been filed by an aggrieved party before the High Court against the petitioner of the present petition, Mrs. Shormishta, wherein Kolkata Police had also made a party, since the aggrieved person was of the belief that the Family Counseling Center was under the Kolkata Police. Such kind of act of counselor in charge Shormishta was not only an exercise of power beyond her authority, but the same was also tarnishing the image of Kolkata Police as a whole. Her high-handed attitude and arbitrary act that she had been sending a wrong and misleading message to the citizen of Kolkata regarding the functioning of Kolkata Police. Accordingly, Principal Secretary, Department of Women, Child Development, Social Welfare was intimated about the findings of the inquiry. I was not given, based on the complaint received from the members of the public, and it was requested to replace the councillor Shormishta with a fresh councillor. In anticipation of the replacement of Shormishta by the department, social such and such, councillor was asked to report back to her controlling NGO, and the supporting home guard and civic volunteers given to her office were accordingly directed to report back to the reserve office of detective department. In reply issued to the principal secretary such and such, the Secretary of Social Welfare Board, Government of West Bengal, requested the Secretary such and such to depute a new councillor for Kolkata Police Headquarters, Lal Bazar, replacing existing Mrs. Shormishta based on the evidences supplied from this end. This is similar how a citizen is being deprived by the atrocities of a state. It is understood from the supplementary affidavit of the petitioner in WPA received by this is the first supplementary of 2023. On 9 September 2023, the petitioner raised issuance of identity card in her name to ascertain her claim to be a part of detective department. The contention of the petitioner is palpably wrong and was misconstrued by her, as detective department, Kolkata Police, at any point of time had not given her appointment. Kindly see, they have accepted that they have not given her my appointment. As a staff of the department, she was working under the Forum of Social Action and NGO through West Bengal Social Welfare Board, who is my appointing authority, under Department of Women, Child Development, Social Welfare, Government of West Bengal. As her work was related to counseling of family disputes, she was placed near to the office of the Women Grievance Cell, Department, Lal Bazar, for convenience. The photocopy of the identity card annexed in a supplementary affidavit seems to be a very old one with no specific date of issuance. The veracity of the ID card has to be ascertained. In regard to the claim of mentioning of family counseling center in the website of Kolkata Police, it may kindly be noted that under the subhead of Detective Department of Women Grievance Cell provides counseling to the women in need in collaboration with French psychiatrists and lady police officers of the cell. The phone number mentioned underneath the above details in the website of Kolkata Police is of the Women Grievance Cell. In no way is the same in any way linked with the family counseling center as claimed. In submitting the present report for kind approval of the Honorable Court, it is to state that the investigating agency has only sought a replacement of the councillor owing to an alleged misbehavior exceeding her capacity. A replacement has also been sought from the concerned department for enabling this department to extend the assistance of family counseling of those who are in need. However, it is stated that the investigating agency is duty bound to carry out any order that shall be passed. Now, my lord, on the first supplementary affidavit I have shown, my lord, and after third, on the basis of this, my lord, I was directed to report back, my lord, my service has been, my lord, come to an end with a cease to effect, with immediate effect. On 31st July, on 14th August, the West Bengal Social Welfare Board, my lord, sent me a letter that there were serious complaints against me, etc., in a writ petition. This was something done. The order is, my lord, before your lordship. Nothing on no such complaint, my lord. There are allegations of, my lord, to directly interfere. The notification permits me to, my lord, do the same, even to the extent, my lord, to investigate into the allegation made against the police officers, my lord, who, my lord, misbehave with the agreed persons, my lord. There have been allegations of past several years. The complaint evidences, nothing was done. So, my lord, this is, my lord, in the fact of this case, my lord, I would only, my lord, humbly develop, my lord, on the 5 points, my lord, for your lordship's kind considerations. Number 1, my lord, my appointing authority was, my lord, West Bengal Social Welfare Board. My lord, he can only, my lord, terminate me. And on the basis of this, my lord, my service came to an effect with effect from 31st July. So there has been, my lord, no 1 month notice, which is a mandatory, my lord, on part of the either of the side. On my second point is, my lord, that even though my appointment letter says that my service is a temporary nature and there cannot be, without assigning any reason, but which when, my lord, some stigma and allegations, my lord, come into, my lord, in the surface, my lord, it is mandatory by the, my lord, mandatory by the Supreme Court that the show cause has to be given. There was no show cause, there was no opportunity of hearing. Now, my lord, my third point that I would, my lord, place to your lordship, my lord, in support of, I would show, my lord, judgment, that Here, my lord, by way of an affidavit, for the first time, or by way of a report, or the first time, my lord, they are trying to supplement, not the supplant, my lord, issues. My lord, in Mahinder Singh Gill, my lord, it is well settled, which is followed by the Supreme Court even till date, that what was not there, you cannot develop your cases by way of any report or supplementary affidavit. So, my lord, nothing could be, since, my lord, in the termination letter, nothing was there, my lord. Now, on support of this, I will only show, my lord, one judgment for the each proposition. I do not wish to multiply. Lordship is no, my lord. Only the facts, my lord, are important. Now, my lord, in so far as 1978 1, 1978 1 টা মতো। না, 405 বলছি ভাই, 405, হ্যাঁ, প্রথমটা মহেন্দ্র সিং।
Yes, give the citation.
এটা বইটা কোথায়? Miller 1978 1, volume 1 SCC page 405. Well, the second copy that I brought from library, I found that those pages are being taken away. It's very unfortunate. I gave my page.
Which paragraph?
Paragraph 12. Well, it is equal citation AIS 78, page 851.
851.
Myla.
What is the name? Mahinder Singh?
Mahinder Singh Gill.
Yes.
Millard.
Okay. Anything further?
Millard, here, Millard, Lordship Millard.
Yes,
Lordship is ever, Millard. The test is, Millard, is that action is to be judged by the reasons stated while making the order.
It cannot improve by
Supplementary reasons in the shape of affidavit, Millard, is to be excluded. Now, Millard, my next thing is, Millard, 2010. Volume 10, SCC, page 614.
What is the name?
Well, it is the name of Chairman All India Railway Recruitment. Do you think? All India Railway Recruitment Board versus Sham Kumar. Well, I would rely on page paragraph 22 and 23.
Yes.
Judicial review conventionally is concerned with the question of jurisdiction and natural justice, and the court is not much concerned with the merits of the decision, but how the decision was reached. In Council of Civil Service Union, the House of Lords rationalized the grounds of judicial review and ruled that the basis of judicial review could be highlighted under three principal heads, namely illegality, procedural impropriety, and irrationality. Illegality as a ground of judicial review means that the decision maker must understand correctly the law that regulates his decision-making process and must give effect to it. Grounds such as acting ultra vires, errors of law and or fact, onerous conditions, improper purpose, relevant and irrelevant factors, acting in bad faith, fettering discretions, unauthorized delegation, failure to act, etc., fall under the heading illegality, quote unquote. Procedural impropriety may be due to the failure to comply with mandatory procedures such as breach of natural justice, such as audio alteram partem, absence of bias, the duty to act fairly, legitimate expectations, failure to give reasons, etc. 23. The ground of irrationality text in Wednesbury unreasonableness propounded in Associate Provincial Pictures Houses Limited, where the Lord Chris Emer alluded to the grounds of attack which could be made against the decision, citing unreasonableness as an quote-unquote umbrella concept, which covers the major heads of review, and pointed out that the court can interfere with the decisions if it is so absurd that no reasonable decision maker would in law come to it. In GCHO case, Lord Diplock fashioned the principle of unreasonableness and preferred to use the term irrationality as follows. By irrationality, I mean what can by now be succinctly referred as Wednesbury unreasonableness. It applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived of it. Now, my next judgment on the issue of 1978 আরেকটাতে কি বার করতো 400 না 248 এটা আছে না এটা Fortunately, the other judgment from the same SCC volume, Maneka Gandhi is there, my lord. 1978, volume 1, SCC 248, the case of Maneka Gandhi,
1978.
volume 1, page SCC, page 248. Mahinder Gill was 405, it is 248.
What is the name?
Maneka Gandhi versus, it is a case of, my lord, a seizing passport, lordship is well aware, my lord. Now here, my lord, so far as a Mahinder Gill is concerned, that you cannot improve the case by affidavit. Maneka Gandhi, the point is, my lord, the rule of natural justice, audio ulterior partem, para 7 to 14, then, my lord, 221 and 182, 7 to 14 and 221 on the basis of rule of natural justice.
7 to 14, 221 to?
No, 221. This is on the proposition of rule of natural justice, and para 8, 11 and 182 on the proposition of audio ulterior partem. My lord, kindly have a look to this.
Okay, I will take it. Yes, then.
So, my lord, on each point, my lord, I have shown, my lord, and my lord, so far as termination of service, my lord, I would like to, my lord, show, my lord, one judgment you lordship must have seen, my lord, also 2001, volume 10, SCC, page 83. Very small judgment, my lord, para 345. Here, 2001, volume 10, SCC, page 83, is a case of AP State Federation of Cooperative Spinning versus PV Saminathan. I'm sorry, my lord.
Paragraph?
Para 345. A short judgment, my lord. 5 paragraph is the last paragraph. Is the only point, my lord, is even a termination of service, simpliciter, my lord, or punitive. It is not a simpliciter, it is something punitive in nature. Lordship has seen, my lord, records. While caused with stigma, the court has to look into the attendant circumstances. Then termination is justified, my lord. Para 3, 4, and 5. I would only read, my lord, one small portion, my lord, for my personal, my lord, legal enrichment, my lord. Para 3. Lordship has seen, my lord?
Yes, yes.
The legal position is fairly well settled that order of termination of a temporary employee or a probation or even a tenure employee, simpliciter, without casting a stigma, may not be interfered with by the court. But the court is not debarred from looking at the attendant circumstances, namely the circumstances prior to the issuance of the order of termination, to find out whether alleged inefficiency really was the motive for the order of termination or form the foundation for the same order. If the court comes to the conclusion that the order was in fact the motive, then obviously the order would be interfered with. But if the court comes to a conclusion the so-called inefficiency was the real foundation of such, then obviously such an order would be held to be a penal in nature and must be interfered with since the appropriate procedure has not been followed. And on the basis of this, here, para 4, in fact, the letter of commissioner, here, this temporary, upon in the court, it was found that the termination was the basis of a letter of a director. Was the foundation for the employer to terminate the service, and as such, the division bench of Andhra High Court was justified in holding that the order of termination is based upon a misconduct, though on the face of it, it is innocuous in nature. So same, on the facts of my case, because I have to show, what are the facts and how, this judgment would be applicable in the facts of my case. The last judgment that I would, lastly, I would put you lordship in trouble, 2020, volume 18. Oh, 2024, volume 11. This is the power of a writ court. 2024, volume 11, my lord, page 324.
Yes. Page?
Paragraph 324.
785.
Oh, I'm sorry, 785. Paragraph 25. In case of, my lord, Vashish Narayan Kumar.
Yes.
Para 25, the last 2 lines. A writ court has the power to mold the relief. Justice cannot be forsaken on the altar of technicalities. So my lord is sitting in a court of 226. which is not a civil code, my lord, unlike. And my lord, 2020, volume 18, page 324, paragraph 4 and 5. Here, my lord, since I find, my lord, this, because I am also now over 60. Here, kindly see, a bare perusal of these two paragraphs clearly show that the division bench of High Court itself was aware that no case of imposing punishment, it is a case of a judicial officer, my lord, who was, my lord, unnecessarily, my lord, put to a punishment. Then the single bench found in his, not in his favor, division bench found in his favor, was aware that no case of imposing punishment was made out. It appears that the High Court was of the view that since the present appellant had been, been out of the job for 8 years, he was aged over 53 years, he should not be brought back in service, such and such. We hold that the appellant has not committed any act of unbecoming a judicial officer. Unfortunately, we cannot do so because now he has already passed the age of superannuation. Therefore, the only issue, how the relief be molded. Should he be granted the entire back wages with interest, or can one lump sum amount be granted as compensation? We are of the considered view that since the appellant has not worked during all these years, and this will lead to another round of litigation to decide what was earning during this period, in lieu of awarding him back wages, we direct a payment of a lump sum such and such. So this is how Read Court can do justice and to ensure law of rule of law. This is my most humble submission.
Yes. Yes, so it's appearing social welfare.
I appear for respond number 6.
Who is he?
It's the appointing authority, your lord.
The Social Welfare Board, my lord.
Correct. Yes.
But kindly takes up the supplementary affidavit of the writ petitioner.
You could give the answer.
Yes.
The order of termination, can you support?
But,
And can you subsequent, you have taken the plea that there is a allegation. How you can support?
But kindly takes up the supplementary affidavit of the petition.
Which supplementary affidavit?
And the affidavit affirming 2025.
2025?
In this writ petition.
25? Yes.
So kindly takes up, my lord, paragraph 6.
Paragraph 6. Yes.
May I place, my lord? That the West Bengal State Social Welfare Board in turn does not directly operate the FCC, and the FCC is the Family Council of Malaysia, but partners with registered and eligible non-governmental organizations and voluntary organizations.
Correct.
In the instant case, the Forum for Social Action is the NGO duly approved for implementation of this scheme across district and blocks. The state board disburses the funds in the form of granting aid to the implementing NGOs, that is the Forum for Social Action, typically in installments subject to compliance with the scheme guidelines, including submission of utilization certificates, audit reports, and activity statements. Now, your lordship has been taken to the supplementary affidavit of 2023, that kindly takes up page 9 of that supplementary affidavit.
23?
Yes.
9?
Page 9.
Yes.
It has been read by my learned senior friend, it's a letter dated 14th of August 2023.
Correct.
Yes, that kindly takes up, my lord, the second last paragraph. In the above context, the police authority has requested this is the Department of Child Development and Social Welfare Department to depute a fresh councillor in place of Mr. Shormishta Raichodhuri, wearing such and such. In the above circumstances, the undersigned is directed to request him to take necessary steps for replacement of Mr. Shormishta Raichodhuri, councillor, and intimate the same to the West Bengal Social Welfare Board for the further course of action. She was removed by the NGO for which she was working, not by the department.
What about the appointment order?
Yes.
95 appointment order?
Yes.
That was recalled?
But kindly comes to page 39,
39 of?
The petition,
Yes.
Your lordship has seen the appointment is purely temporary in nature.
Correct.
Kindly have a look at this document, my lord, and the subsequent document. Now, this letter was addressed to the.
What you are filing? What you are filing?
Now, this is a compilation of the document that instruction of the department has sent me, my lord. Kindly have a look. If your lordship.
Why you not place all the things in the report?
This is a report. This is for your lordship's convenience, and I have flagged it up, my.
What? No, earlier occasion you filed the report.
No.
That is filed on behalf of the state authority.
That is by the police Lal Bazar.
Police Lal Bazar.
I'm sorry, welfare board.
2023 or not, when this application, this writ petition was filed.
2023, immediate after this one.
You have not filed the report.
And the order of last was 6th of August 2025, my lord. And it was not served upon us, my lord.
What?
Instruction petition.
Well, every day they were appealing.
Petition as to the report served, my lord. This is a report that we have prepared for your lordship's kind convenience. So kindly have a look at the contents of this letter.
Yes. You are the R6.
Yes, I am DS point number 6.
Yes.
Now, this letter has not been made part of the writ petition. But kindly see, my lord, the contents of the letter.
You are relying upon this.
Yes.
So you have served the. You served the copy. Come, you go through this. Henceforth, all the advocates, if you want to file the report before hearing. Why you not mention this? You wanted to rely upon the report before starting the hearing. I am putting the cost upon you. I am putting the cost upon you. He had 1.5 hours. He has wasted the court time. Now you are coming with a report without serving the copy to the petitioner. If you want to rely upon, then I will put the cost. I will take and record. You will not rely. I will record your submission. Sure. Case is mine. You will not rely upon this document.
All these documents are also there in the writ petition, my lord.
Show me. Then why you are going to that?
Then he says that I did not disclose. Is there, then why are you saying that I have not?
Contents of the supplement.
So.
By the 2025 the affidavit.
2025?
Affidavit.
Yes.
But kindly come to annexure A, my lord, for once.
Annexure A page?
Page 15.
Page 15, yes.
So this is the honorarium slip for the month of April 2022, September 2020.
Correct.
And she was not receiving any salary. She was only on honorarium.
Correct.
Now, this policy, it was operated by the central government.
Correct.
Now, from 2023, the central government has stopped this policy.
Correct.
So, this policy as of today of running these centers, has been stopped. Now, for the purpose of this, the state board has transferred all these centers to an NGO. Now, this is run totally by the NGO, as your lordship would be finding from paragraph 6,
Which paragraph 6?
Of the supplementary affidavit, I just placed your lordship.
Yes. NGO. Correct.
Yes. But paragraph 8, kindly see, and paragraph 7,
Paragraph 7.
The implementing NGO, having received the grant, becomes the direct disbursing authority for the monthly honorarium of the appointed family council. Not everything, there's no involvement of this case, it is run, function, it is operated through NGO, the NGO has now removed her. We only say.
Where is the NGO? Who is the NGO?
The NGO is Forum for Social Action.
Yes, Forum for Social Action. Kindly come to the impugned order. Kindly come to the impugned order. 39.
43.
Yes. Kindly come to the impugned order.
Yes.
43. Who has issued this?
The policeman, Kolkata policeman.
If you are telling that it is the NGO, so whether the police is the NGO?
The police only say.
Just.
Is
the Kolkata police only say that your place, as of on that date, the place of working of the petitioner at Lal Bazar, they said that instead of working at Lal Bazar, we are reverting back to your NGO. Your NGO will place you. But kindly see the contents of the letter.
Yes. Come that.
To report your concerned authority from DD. But the concerned authority will be the NGO,
Correct.
With immediate effect, and also inform to you that supporting staff of your office PD are hereby returned and report to reserve office immediately. But it does not say anything about termination,
Where is you are appearing for?
Response number 6,
Response number 6. This is not issued by you.
No, it is not issued by you.
Now the police authority has submitted the report. Whether the police authority has taken this plea? The additional superintendent of police has filed this, or additional commissioner has filed. Whether he has taken the plea, what he is submitting?
Lordship,
have you heard the submission made by this social respondent number 6?
Lordship, I am coming, Lordship.
I am putting only one question, sir.
Lordship.
Have you heard what the submission he has made?
Lordship, I have heard.
Correct.
Lordship.
Have any averment in your report that is the NGO we have not terminated? It has been sent to the NGO. Where is your report?
We have not says anywhere regarding the termination.
So how you can say
termination? Because, Your Lordship,
how you can improve the case?
the
of the
language,
police?
the language of my letter under challenge is very much clear. We are neither we are appointing authority nor we terminate her.
That's why. But you have taken the stigma. You have taken the total
Only
stigma.
we withdraw the supporting staff given to the.
I appreciate, but 5 pages report you have put the stigma upon the petitioner. If
Lordship.
the petitioner is not on your control, how you put the stigma?
We have received various.
Okay, if it is the only thing, this court could have been appreciated. Yes, you have directed to go to your NGO, but the 5-page report,
Lordship.
you have put the stigma upon the petitioner. What is your answer?
We have received several complaints
Correct.
against the petitioner.
Correct.
On the basis of those complaints,
Correct.
we inquired the matter,
Correct.
higher authority,
Correct.
and we found
Correct.
she has done something wrong,
Correct.
which we given the indication there in my report to the higher authority of the.
Who is the higher authority?
That is the detective department. I am coming, Lordship.
Correct.
Lordship. Thereafter, we withdraw the supporting staff given to the petitioner. Nothing else. We have asked the concern.
You have submitted the report. If it is a stigma, whether you mention that you have done so and so and so, that's why you report the matter.
From the page,
where is the notice? Where is the
page
opportunity
9,
of hearing
page
to the petitioner?
Lordship, it appears
Where is the opportunity of
page
hearing?
9, Your Lordship. This one, page 9 of the supplementary affidavit is the letter issued by the joint secretary to the government of her.
Page 9.
Page 9 of the affidavit filed on 4th September, from 1st September. This is the letter joint secretary to the government of West Bengal, written to the secretary, Forum for Social Action, where we have mentioned in second paragraph, as per report of the Calcutta Police Detective Department, Lal Bazaar, there have been numerous complaints against Roy Chaudhary, like threatening, pressuring the clients, demanding money from the complainants. Edit petition such has been filed.
Forum social action.
Action, Lordship.
Is they are the party here?
We have only given.
Yes, they are the party here.
Lordship, she's appearing by.
Huh? NGO. Yes. So what you have done after receipt of the complaint? 8 of the
supplementary affidavit.
Which
affidavit?
One line, may I add, Lordship? Police authority only provided a space to run the counseling center in Lal Bazaar.
Let me see. Yes. What has happened after the page 9 you received? What you have done?
I have requested her. Page 8.
Where is that?
Page 8.
To the counselor, family counseling center, police headquarters, Lal Bazaar. No, you ask for the resignation. When you ask for the resignation, August 2023. What is the date? 19th August 2023. You have received on 14th August. Have you submitted this report? Ask for the opportunity before issuing the resignation. You have received on 14th August 2023 the allegation against the petitioner.
Yes.
Correct. There are several allegations. You have received that. And on receipt of this allegation, now you come to page 8. Page 8. You, in the light of the above directive, as per the directive, you are directed to submit the resignation. Has he submitted the resignation? No. And please, And this complaint has been served with giving an opportunity to give reply what you have committed. Huh? Where is the letter?
If you have anything, you can send your reply within a week. This time.
In the light of the directive, you are asking upon the directive for resignation. Where is this letter you have forwarded? 14th August 2023, where you have forwarded? Show me. You have anything to say, you may send your reply.
Not file any resignation.
Leave aside the resignation. Whether this complaint which has been received by you, have you forwarded to the petitioner? Where? Show me.
My lord, these have been forwarded by.
By which letter?
I have any colleges letter to.
You stated that please find enclosure with
Kindly, please find the enclosure.
Yes, what is the enclosure?
And the next page that your lordship is checking, page 9. The lordship would be seeing at the top, the memo number is same.
Where is the memo number?
At the very top, WB/FB/FCC. So your lordship would be finding the enclosure.
200. Dated 14th. Yes. You are not ready with the matter. Yes.
Well, only one thing, my lord. The funds, which is to come, but this was at the behest of the central government. But from 2023, the central government has stopped sending funds for this project, So this is also my submission as of today. There is no funds from the central government to operate these counseling centers.
That is, yes, not asking. Yes. What is the submission?
Lordship, we have only provided the space to run the counseling center. Nothing else. I am the state authority and the Calcutta police appearing. We have given the space in the detective department because that department is very near to the women's cells, and she's to run the counseling center.
Yes.
When we have received the several complaints against her, we withdraw the support to run the counseling center. Ask the concerned authority. We are withdrawing this support to the petitioner, lordship. We are neither appointing nothing, nor we have any authority in this matter. We only voluntarily provided the space for the betterment of the society.
In your lordship's finding, may I make one submission?
Yes.
At page 8, your lordship has found the data is 19th of August 2023.
Page 8.
Yes,
of
the supplementary affidavit. This is a letter, but rightly or wrongly, this Forum for Social Action has now sought for a resignation. But this letter, perhaps, is not challenging any of the writ petitions. So, in that context, your lordship will entertain this writ petition at all. Your lordship allow this writ petition at all, because this Forum for Social Action is this Forum for Social Action is an NGO who has sought for resignation of the petitioner. So in this context, your lordship will entertain the writ petition. I must place your lordship's kind consideration.
Yes, you speak.
But this Forum for Social Action is an NGO who has sought for a resignation from the petitioner.
Correct.
But this Forum for Social Action is for a state authority,
Correct.
not an Article 12 authority.
Correct.
But in this context, whether the writ petition itself would be maintainable by you.
Why you not argue before the petition?
But I had said,
so why you not argued?
I said that please, whether the writ petition is itself maintainable on these
facts. How many years you are having the practice?
10 years, my lord.
Then
I have raised.
Once you are taking the mentality, you could have been argued the first. What is your name?
Orkodipto Sengupta, my lord.
Who is your senior?
You
answered or
I was attached to the chamber of Mr. Aurobindo Chatterjee, senior advocate, my lord. And now I do on my own, my lord.
So that is why he was not there. I am asking, you are not raised that time. This is not maintainable. You are starting on merit.
Right.
You started the matter on merit when he was asking the time.
I'm sorry, my lord.
Before this court, this will not allow. If anybody wanted to argue the matter on mentality, you have to argue the first. Yes.
That is the consistent rule that your lordship follows, and it's a usual practice that I have learned from the very first day.
Correct.
Of my.
But I think all the rules have been changed nowadays.
I used to work at my senior's chamber till 4 o'clock in the morning. or at least 3 o'clock in the morning. Then he went to sleep and he was, he had really thrown me out of his chamber and now says he's now home.
Yes. Anything further?
The judgments relied on by my learned senior friend, my lord, but those are my perhaps will be distinguishable on facts, my lord. And if your lordship for
Hearing concluded, CF.
can we file a written notes, my lord, for your lordship's
Hearing concluded, CF.
Yes,
You
written
want to file
written note, if your
you
lordship.
will file.
No, only 2 points on reply, not more than 2 minutes. So far as this page 8 that was shown, in my supplementary affidavit, initially they say, I did not disclose. Everything are before your lordship. Page 8, if your lordship see, the forum of social action or welfare or whatever it may be, it is something, an implementing agency on behalf of the social welfare board. The social action, this NGO, cannot have any independent form and action. My appointing authority is the social welfare board, is an admitted fact. They are not denied. So my appointing authority can only, dismiss or end my service. That is what the social welfare board has done at page 9. He says that since because the NGO is coordinating, social welfare board by its letter on 14th August, they say that you end her service. So that is what the forum actions have said. And here the mind is said that we are terminating. So when the decision has been taken, what was there left, for me to say something further? Second point is, so far as there's a funds are coming or going, I have been paid through West Bengal Social Welfare Funds. The funds are coming from Central. It is a state body. So, my action is against the Kolkata police as also against the Social Welfare Board. And so far as a Kolkata police's their submissions, they say that we only provide office, but they casted stigma on me. There was an allegation. Inquiry was not done by Social Welfare Board. Inquiry was done by Kolkata police. And on the basis of them, who neither pay me the salary nor my appointing authority, my entire service from 1995-2023 for 20 years was all on a sudden came to an end with certain allegations. And who am I? I am also a woman.
Okay, thank you.
So this is my submission.
Written notes can we file?
Huh?
Written notes, my lord?
You want to file notes?
Or just 2 page notes, my lord?
Lordship, I will.
Ekta record kar rahe? Yeah, counsel for the parties have concluded their argument. Counsel for the respondents wait for time to file written notes of argument. Let the written notes of argument be filed by
1 week, the next Monday, Lordship.
by 1st of December
Next Monday,
2025. This is the matter on 1st December 2025 under the heading to be mentioned only for filing written notes of argument.
Well, that's cited, 5 judgments, 3 have given copy, 2 have not.
Just 2 has not given, 78.
70. That I would give, Lordship has passed an order, fixing time again,
No, only written notes of argument I see here.
When?
First December you file the written notes of argument.
Well, I'm extremely grateful, for patience hearing.
Next.
I'm obliged.
December to be mentioned.
To be mentioned only for filing written notes, nothing else.
Grateful lordship.
অন্য কোথাও চাইছি
Is there any there online? Yes, it is there though. The last one. Manoj Pal, item number 1. Not online. Yes, Mr. Paul.
Sir, is it audible, sir? Is it audible, sir?
Yes, it is a matter.
Sir, actually, in this matter, that in the Honorable Supreme Court, Justice Gawai Charan passed an order directing that Peace Hajari Court at Delhi to appoint advocate on my behalf before all the courts at Andaman Nicobar.
Ah.
But at this stage, I want to file quashing petition for some of the FIRs which has been registered. I need an order that where the direction may be issued to the High Court Legal Service Committee for to appoint advocates on my behalf to file quashing petition for the FIR, sir.
Where is the FIR number? Where is the legal aid counsel to cause the FIR number? How many FIRs are there?
Sir, actually, there are, I think, 17 FIRs, sir.
No, you have mentioned in your prayer. Kindly come to the page number 14 or 17 of your petition.
17, page number 17. Page number 17.
Please to appoint a legal aid counsel to cause the FIR number 121 of 24, 55
Yes.
25, 29 of 25, 24, 24, FIR number 22, 22. These are the FIRs.
Yes, sir. These are the FIRs. Actually, some of the other matters are at the last stage of hearing.
So okay, you do one thing. I am calling a report from the registrar of the circuit bench at Port Blair to provide the name of the legal aid counsels from the Port Blair, and let it be served to you. And next date I will appoint.
Sir, actually, the no advocates at Andaman Nicobar is willing to appear on my behalf. There are, in the past also, the many advocates has been appointed, but they are not willing to appear. So that is the problem, that I want an independent, the advocate who should do impartially my cases. Otherwise, sir, I will suffer, because if the
From where you want to appoint the legal aid counsel? From Calcutta?
Yes, sir, High Court Legal Service. Because in the earlier order also, as per the Supreme Court direction, in a bail matter, the advocate Meet Guara was appointed, sir, by the High Court Legal Service Committee. So he is well acquainted with my cases. So advocate Meet Guara may be appointed, sir.
I don't know whether he is in the panel or not at present.
Yes, he is in the panel, sir. He is in the panel, sir. He is in the panel, sir.
Yes, who is in the...
Sir, otherwise, because I'm fighting elections, sir, I have other works also, because unnecessarily they are filing false cases where I am not living at Port Blair, sir. I am living at Delhi. They are filing unnecessary cases against me just to harass me physically and mentally and emotionally, sir. And financially too, sir.
The petitioner has filed the present writ application praying for appointment of legal aid counsel for for filing an application before the Honorable Court for quashing of several FIRs registered against the petitioner. He submits that the advocates appearing and the advocates of the legal aid panel from the Andaman and Nicobar Islands are not interested to take the matter of the petitioner, and accordingly the petitioner prays for appointing any of the advocates from the legal aid panel of the Calcutta High Court. In view of the above, the Registrar General of the Appellate Side is directed to place the list of the advocates of the Calcutta High Court, list of the Calcutta High Court Legal Service Authority before this court on the next date fix. Let the matter appear on 2nd December. I am fixing at 1 p.m.
Sure, sir. Sure, sir. Thank you, sir.
Let the notice come, let the names come, then we'll see to that.
Sir, in the page number 27, you can see that Justice Gawai Charan passed an earlier order. So that order can be seen in the page number 27 of this petition, sir.
Yes, I have gone through, but let the report come, let the names come, then I'll pass the report.
Sure, sure. Thank you, sir. Thank you, sir.
1st of December.
Thank you. Thank you.
second.
My lord, may,
At once. Yeah.
my lord, may kindly permit me to mention one matter.
The order may be communicated to the Registrar General for compliance. Yes.
My lord, may kindly permit me to mention one matter. My lord, today's item number 17. My lord, may kindly fix it
Item
at
number?
17.
Ah.
My lord, may kindly hears it at 2 p.m. My lord,
What is the urgency?
because my lord, I'm getting married. So today is the last day I'm coming to court. My lord, I'm getting married within 3 days.
2 PM matter hai? Fix hai?
My lord, this will take just 5 minutes.
What is the matter?
This electricity matter, it will just take 5 minutes. My lord, I have to.
Give.
Item number 70.
Give the item number, sir.
My lords, may I please mention item 26 and 27? My lordships.
Yes.
And the lordship petitioner is the occupier of a building, lordship. Lordship petitioner applied for a service connection, electric service connection piece of this for the said building, lordship. The CSC authority thereafter made inspection and lordship kindly sees annexure P1. They have rejected that there is already a service connection exists in the said building. But the said building does not have any service connection. Lordship, on the last occasion.
No, as finding from the site inspection indicate our service already exists in the premises.
Lordship, that said building has no connection. In the surrounding there are connections. The building is getting connection from one of the meters in the neighborhood. Lordship, on the last occasion, the matter was moved before Justice Chondu. Justice Chondu directed the CSC authority to file a report.
Correct.
My lord, I'm filing the report. My lord, we have gone for the inspection and we have found that, my lord, we have found that the electricity is there and the petitioner is enjoying electricity. My lord, we have annexed a, photograph, my lord.
That is in the name of a different person, lordship. And the same
In whose name the meter connection is there? In the name of the Lakshman Oja and 20 others.
My lord, yes, and
the petition is getting supplied through the block meter bearing so and so standing in the name of Lakshman Oja and 20 others.
My lord.
So all the flat occupiers of the 4-story building are getting supply from the aforesaid block.
Lordship, 1 meter and all the flat owners are getting connection from 1 meter. I am paying this connection for the said building. Lordship,
my lord, he is getting connection. He is getting connection from a block meter, my lord. Then why a new connection is required, my lord?
This is the main service connection of the CSC authority. For this building, they have annexed the photograph, lordship. The next page in the report.
Yes.
For the said building, I am paying for one service connection and meters will be installed in the service connection.
Service connection, then first the line has to be put from the pole to your building. That will be service connection. Then a meter will, the loop meter will be provided to you. So if why?
My lord, as
already there is a meter.
My lord, as
no service connection over there. So
no, my lord, this a block meter is there, and they are every one of them are already getting supply, my lord. Then
how the block meter from the block meter so many connection has been provided? This is not dangerous.
No, my lord, there is no need of new.
What is the capacity of the block meter?
This is these
20 persons, 20 and other persons.
My lord.
Then
Lordship, kindly see the photograph in the report. Lordship, these are congested place, lordship. And lordship, block meter may have been provided for one of the slum, but this is a building, lordship. And there are other occupiers in the building. I am paying for one service connection in my name so that other occupiers can get connection from the said meter, said service, lordship.
So this is the service connection. So you provide the loop meter from that.
My lord, for that he has to raise his grievance to the GRO, my lord, to the grievance redressal officer.
There is no order you passed. Where is the order?
My lord, that order was not passed because on the last occasion, Justice Chanda has said to conduct further inspection, my lord.
In their rejection, there is no statement of any regulation or anything. And as per section 43, my building is entitled to get the connection, lordship.
So what can be done? It is feasible from the one block meter, so many connections can be provided. As per your
But,
report.
but my lord, if we give service connection to one, then every other will.
How the meter will be, how the amount is distributed? How the bill amount is to be distributed amongst 20 or 24 persons? In whose name you are raising the bill?
And Lordship, this Lakshman Oja and 20 others, these person do not reside in my building, Lordship.
You are in second floor and they are in fourth floor.
Same building, my lord, the floors are different.
You are in second floor, they are in fourth floor.
The difference is.
It is getting
no
supply
floor.
block meter so and so in the name of photographs.
It is entirely a separate building, Lordship. It is evident from the photograph of the CSC. I am saying that that building may be given a service connection.
But as per the instruction I have, my lord, this is not a separate building. They all live in a same building, my lord. It's a 4-storied building.
Yes, I am paying for the 4-storied building.
Now the difficulty is, my lord, if everyone comes and asks for a separate service meter.
This meter is situated in which building? Because kindly come to your paragraph 1. During inspection, we found that the premises number is a big plot of land. We found the petitioner is residing in the second floor of the 4-storied building. Presently, petition is getting supplied through the block meter bearing so and so standing in the name of Lakshman Oja. Correct.
That is
All the
stated
flats
nowhere
occupied
in
of all the 4-story building are getting supply from the aforesaid block meter. Since the petition is getting supply from the block meter, it's not entitled to get another connection. So this is only one building.
Yes, my lord, this is only one building, my lord.
49 by 1 Kalmak Saroni, Lordship. It's a big plot of land.
But the dispute
Big
is
plot of land, but the
dispute
building
regards to one building, my lord. The
This one, the
you are in second floor
yes,
and they are in fourth floor.
yes, my lord.
they are in 4th.
I don't need all persons. All
All
persons
persons
of the
are residing in the same building, my
all
lord.
persons of four stories are getting the same. So how it is possible?
Lordship, they are not stated anything about their floor.
Correct.
Only I am deciding.
How
on the
it is
second.
possible? For 1 meter, the total connection is to be given. How it is
That
possible?
meter is also not for my building, Lordship. It is for the area, Lordship, and I am paying for only for that building.
Who is the competent engineer?
District engineer.
District engineer, my lord. District,
Let us file the report.
as your lordship pleases.
Because how from 1 meter it is how the so many loop connection can be provided.
It specifies that whether this building is getting any specific connection.
Stated that. In the report stated that second floor.
Second floor, Lordship, I am residing. But these Lakshman Oja and 20 others do not reside in my building.
They are not residing in the same building.
But the instructions I have, my lord, they are living in the same building, my lord.
In terms of the order passed by this court dated 26th August 2025, the Senior Engineer Southwest District CESC Limited has submitted the report stating the following 1, 2, 3. This report. Correct. The petitioner has raised objection that the Lakshman Oja and 20 others are not residing in the same building. And this court also did not find any clarification whether the said meter connection is provided in the building where the petitioner is residing. Accordingly, the Senior Engineer Southwest District CES is directed to file a supplementary report specifying that whether the meter number 381733, consumer number 14056083081 is provided in the building where the petitioner is residing, or whether the said meter is provided to some other building. Let the said report be filed by.
My lord, kindly keeps the entire matter on January, my lord. My lord, kindly, my lord. Kindly.
Without electricity,
No,
Lordship.
it is not without electricity, my lord. It is not.
You are having any colleague? Let's
My-
connect. I will regularize there. Who is your colleague?
My lord, I can ask CSC to.
File the report by how much time it will take? 1
2
week?
weeks minimum, my lord. 2 weeks.
2 weeks.
My lord, 2 weeks is needed, my lord.
By 9th of December 2025. List the matter after serving the copy to the Land Council for the petition. List the matter on 10th of
Lordship, under the heading urgent motion, Lordship.
under the heading urgent motion.
Grateful.
Grateful, my lord.
My lordships, may I please mention item 26 and 27, my lords?
raise up upon the opposite party. Can you, my lordship, can you please give a day, give a time at the end of the day today?
Today it is not possible. 2 p.m. other matter, today is 3:30.
But my lord, my matter is quite urgent. I'm into rented accommodation. I'm facing various harassment. There is no rent agreement. We are giving them the money at time. They're taking the money. After taking the money, after 4 days, 5 days, they're asking to vacate the premises. And every time I have to take.
How the landlord tenant can be taken into consideration by the RIT?
My lord, every time I have to go to police to get the service, and it has been mentioned in this code, my lord.
Go to the civil court, file and suit and get an.
But my lord, when I mentioned on 18th, you have allowed me today 37.
Mentioning, that's why you mentioned it is listed as an urgent motion. When the urgent motion is more than that, what can be done?
My lord, if you can permit myself, because my mother is in a issue.
Correct, madam. Now already matters are fixed.
At the end of the day, my lord, if you can give me a kind hearing.
Because 2:30, 3 o'clock, the other original side matter is fixed.
My lord, if it can be tomorrow.
Can come tomorrow, we'll see to that. Come tomorrow. Yes, next. Call.
My item number 32, my lord, I appear on list of the respondent number 2. No copy has been served, my lord, that is. Where's the affidavit, sir? My instruction, we've served everybody, my lord. Who
is the respondent number 2? Who is the respondent number 2?
Respondent number 1. আপনি জানছেন কি করে আপনি respondent? আমাকে ফোনে
Insurance company.
He is my person who had surveyor who had appointed, the broker. He is not even the answering respondent.
Yes.
There are various allegations, counter allegations against the person now.
Aeon, it was delivered by hand, my lord, on 14th of November.
Page 4 of the affidavit of formation.
Yes.
My lord, my mail, my WhatsApp, my lord,
He has
instructed me
received
to.
instructions to
He
appear,
has.
but he has never got the copy. That is what they are saying.
Sir, the copy.
I'll give him a copy now.
Yes. Sir, the copy.
I'll continue. No?
Yeah, there is a report delivered.
And he received it by hand also.
17 November.
14 November by hand and 17 November it was delivered.
Your office has received. Yes. Yes.
Yes, no, the issue is here short. We had
Mr. Sinha.
One.
Main. He's the main respondent.
Yes.
Interview now. Well, if you're taking the point of interview, then take the point of interview. Huh? But he's murmuring something on maintainability. If he's taking the point, then let him address.
I will take all my points at the same time. Let him, my learned
with maintainability.
Perhaps on form also.
Then let him take that point. The maintainability, he'll take the point first. I'll deal with it.
Let him argue. I have not filed anything. Otherwise, I'll file something. I have not filed anything. So let him take the whatever points he has, and thereafter we will take.
Now, whether you are taking the maintainability point, then I will hear you first.
Correct.
If you are not taking the maintainability
Then
point, you want to argue the matter on merit, then let he argue. Then I will give the chance.
Your Lordship will have a look at the cause title and the second petitioner.
Apart from that, অদ্ভুত point.
They are proposing to take rights under Article 19. And for that, they have to have a citizen. That is why they have done this. But unfortunately, what they have done is,
when a company with that person, the second person, citizen has to be brought in, it is a member or director of the company, a member of the company, not an employee of the company. The employee's rights are not coterminous with that of the company. So Article 19 rights, they cannot envisage. That's why I said I'll take the point later on. It's not that reputation is not maintainable, but no Article 19 rights will flow.
May I just start? Lord, this we had troubled your lordship on the first day. The issue is very, very short. My lord, এটা কোথেকে আসছে না? আমেরিকা থেকে আসছে না? Detroit. These were pet coke that I was getting from Dallas, and it's coming to Kolkata. Now, there is naturally a clean bill of lading. My insurance covers warehouse to warehouse. When the goods come, reach Calcutta, I'm informed by the port that there is water. So it comes in 5 different cylindrical columns, which we call hulls, which are called hulls. 5 has my goods. Hatches, sorry. It has.
Ship, in the ship.
I'm sorry, Miller. By a ship, yes, it's ship.
Hatch.
It's hatch. Those 5 things, it comes under. 3 out of 5 or 2 out of 5 is damaged. So when we are informed by the port, we go to take it. It's seen that there's water that's leaking out. So we immediately write to them saying, please appoint a surveyor, come and assess the loss and do that. They finally appoint a surveyor 3 years later, 2 to 3 years later. And the repudiation has come in 2025. I have assailed the repudiation, had shown that your lordship on primarily 2 counts. One,
when the incident was occurred,
2022. Your lordship remembers the 2022, this happened. 22nd August 2022, I informed them. And then there are repeated emails saying, please appoint a surveyor. Surveyor finally got appointed. What we finally call it?
Yes.
The surveyor has given a report in 2025, and the repudiation has happened on May 2025. Surveyor's report I had shown to your lordship. They have said that they can't comment and the liability cannot be denied. What does the insurance company do? Insurance company borrows, in the repudiation letter, the clause from the contract, applies that, adds 2 words to it to reject it. My 2 counts on which I assail the repudiation because it's unjust and arbitrary. My attack is on Article 14. The right under Article 19 I'll come to later. That's a different aspect. But
So
here,
now what you prayed? Interim order?
no, my prayer before your lordship would be to set it aside and have them reconsider it on the terms of the insurance policy. That is all I pray for. I am not beseeching the court to ask them to make the payment to me. But the consideration resulting from the insurance contract has to be fair. This has what as your lordships have always had. The repudiation can't be unjust. You cannot alter the terms of the policy to repudiate my claim. So my only case today is this be set aside and they consider, in fact, we had requested Mr. Sinha to also take instruction on whether he's agreeable to this. But seeing the number of books he's got, I don't think he'll agree to that. So he is not agreeable. So what I pray for is that the consideration must be on the basis of what the insurance contract speaks. It can't be any other consideration. If you have applied any other consideration,
then in case if at all the court satisfied with your submission and set aside, and you are telling that it has to be remanded, then
yes,
it is the second round of litigation.
Yes, ma'am.
Correct. Why you are not directly, because if it is the civil case, if it is the civil court, there is no question of further consideration. The civil court will say whether the reputation is correct or not. If it is reputation is not correct,
I understand.
Automatically you will get
yes.
the claim.
Yes.
What is your damage? You have to prove.
That's right. I have to go ahead, and so that's the aspect. That is where your lordships have always held that where the repudiation is contrary to, it's like a bank guarantee.
Correct, correct.
It's like the bank guarantee thing. So if the repudiation is contrary, like invocation contrary, that also writ court interferes. Here also insurance contract.
I'm not telling on that the writ court cannot
No,
interfere.
I understand. No, your lordship has just put a very natural query to me that why aren't you getting it done there? Because unnecessarily I'll be doing another round.
Another round.
My lord, why I want this done is when this is going to happen, they will have to consider the policy as the policy exists. My consideration of loss. Lord, may I just do those two letters if I could just show. Please have a look at page 83 once.
83 read with 227.
Please have a look at page 83.
227 is here.
Yes. Losses due to heating, sweating,
That's right.
contamination, adulteration, deterioration.
Yes, exclusions, my lord, your lordship, I had shown this the other day. Losses due to heating, sweating, contamination, adulteration, deterioration of quality, unless caused by, so if it is caused by ICC-B perils, then it's not excluded. But if
What
it's
is the ICC-B?
that's another part of the policy. Two types of perils are covered. I come under ICC-A. So if these are all excluded ones, which are, so it has to be heating, sweating, contamination, adulteration, and deterioration of quality.
Correct.
Now, your lordship will just once have a look at page 227.
This is the repudiation.
Yes, ma'am. Paragraph 6. This is repudiation.
227.
This is their reply from the repudiation also. I'll show that. But I may just, if I may just page 227, show your lordship page 6, paragraph 6.
Moisture.
And I'll take your lordship back to the repudiation ones. We vehemently deny the contents of paragraph number 1 and 2 of your notice as false and frivolous. We would reiterate that even though the policy is governed by ICC-A clauses, the coverage of any loss due to heating, sweating, contamination, adulteration, moisture, condensation, deterioration of quantity, quality are excluded under the policy.
Correct.
But here, a very pertinent question your lordship had put to me when I was moving it the first day. Please have a look at the surveyor's report once.
Page number 240.
It starts at 240.
Relevant is at 323.
323.
This page 227 is what is this? This is a repudiation.
227, my lord, when they repudiate, I write to them saying you have taken into consideration extraneous factors. This is not even a part of my policy. So how have you gone ahead and excluded or added these things?
Correct.
So this is their response where they reiterate. And there they add, and I'll show, my lord, because your lordship had put this query to me. 320?
248.
323, part of the surveyor's report.
Yes.
Why the word moisture was added to the repudiation? 323, just the summation of the report. Immediately after that box, not in the middle of the page. To sum up the matter, we wish to state that keeping in view the findings of Haldia Port authorities in the above shown two emails, it is very difficult on our part and or not in a position to deny or dispute the presence of water inside the hash number 1, 3, and 5 of the vessel. In view of the above stated facts and circumstances, we cannot comment on the acceptability or deny the liability. However, we are leaving the final decision at the discretion of the underwriters. So moisture and unable to actually deny the liability. So what does the insurance company do? It uses moisture as a ground. If I may just come back to page 227 once. Two things from paragraph 6 are admitted. That there is moisture and that there is deterioration of quantity.
Correct.
Because they use these two grounds to repudiate. But they say that this is part of ICC exclusion, therefore I'm not going to do it.
My solitary scope of challenge here before your lordship is that my
So your case is that the deterioration due to the moisture, water coming inside the hatch.
That's
That is
right.
your case.
That is my case.
So that's why it is contaminated
It-
due to the moisture
Yes.
of the water.
So what happens is, when
entering
I'm
into the
taking
hatch.
that hatch down, it becomes a slurry. So a slurry actually goes out. That water with that pet coke, it actually gets washed out. So that is caused by moisture, and the quantity naturally reduces. So I keep this repetition scope only to this. Now, apropos the repudiation, 213. Please come to 213 once. Here again, one word is added, one has been kept out.
Page 213 is the repudiation.
213 is the repudiation. Well, the penultimate arrow. There are no details of the quantity and moisture content of the pet coke for the cargo discharge at Paradip Port. The draft survey report of the cargo discharge at Paradip Port for the unknown consignee was not provided by the insured. Therefore, the manner in which, I'll just indicate what this means. When my goods were being shipped in one, it was there for another person also. Goods that belong to me and other people also. So that bill of lading which is generated is naturally in respect of that. So the bill of lading it's a clean bill of lading. They say that you did not inform me that that will have other people goods in that. So this second sentence is apropos that. The draft survey report of the cargo discharge at Paradip, this is for other people, for the unknown consignee, was not provided by the insured. I have no privity with them, nor does the insurance company. So for the insurance company to ask for that is absolutely an irrelevant consideration which flows from the next four lines. Therefore, the manner in which the loss has been calculated or quantified is arbitrary. And it is stated that an effort has been made by the insured to justify an unexplained shortage. The insurance policy excludes rejection and quality shortages, and also unexplained shortages, condensation, moisture, etc., unless caught by ICCB perils. Well, if your lordship just looks at the last sentence of that page, the above SOF was signed with stamp. Last sentence, last four lines of that page.
Yes.
The above SOF was signed with stamp by both your representative and master of the ship after unloading cargo at Holdia port. From the SOF, it is clear that increase in moisture content is just because of ABC. So the ground on which
inherent voice, nature of cargo, and settlement of water in the hold. Settlement of water in the hold because the wet condition of the cargo.
And again, your lordship will see C. I mean,
no, the B, they are telling that there is no
proof of
damage.
leakage or damage in the ship's hold. And C, there is no mention of occurrence of any ICCB peril. An entire consignment has been received by the insured without any shortage. So they go to deterioration of quantity.
Correct.
When I write to them saying, what have you done? This stand is now reiterated at 226, what I showed.
Yes.
So they have actually imported two words and used that clear, that moisture and deterioration, because their focus appears to be moisture and no shortage in quantity. This is actually not even part of the insurance. I have suffered a loss, and that bill of lading I'll show to your lordship once.
Page number 108.
Please have a look at 108 once. The pagination, I hope your lordships is slightly better than mine.
Same.
It'll probably be the same. 108 is.
Yes.
Right hand corner, please see. Bill of lading. Clean on board July 7, 2022. Somewhere in the middle, my lord, your lordship will find shipped at the port of loading in apparent good order and condition on board the vessel for carriage to the port of discharge. My lord, there are a lot of issues I understand is probably going to be raked up by the respondent, this insurance company. I am keeping it to just one solitary point, because beyond that, in the writ court also, I really can't probably invite your lordship to get it right. But the consideration has to be apparent from the repudiation. And that repudiation cannot be unjust. The moment, not very consciously, and I'll back this up with two judgments, the moment there is an unjust repudiation, the unjustness is available from the repudiation kept against or placed against the insurance document. Here it is very clear that they have had to import two words, one word and one condition to actually repudiate. To just buttress this point, Supreme Court, 2001 question.
Which one, Sikha?
This is the LIC judgment, not very no. Very oft-cited. This is 2001, Volume 2, Supreme Court Cases, 160. Paragraph 10 and 11. Article 226. No, Mr. Sinha wants me to read 9. These are all, we fire these shots in the blank. That if I know the judgment, please the period paragraph. I'll place 9. In course of his arguments, so and so appearing for the corporation fairly stated the corporation will pay the sum awarded by the in favor of the respondent. He submitted that the position of law regarding the jurisdiction of the High Court to entertain writ petition filed under 226 of the Constitution for realization of a sum assured under a life insurance policy and the scope of inquiry by the High Court in case the insurer repudiates the claim on any ground may be considered by this court. Thank you, Mullah. I should have actually shown this. Article 226 of the Constitution confers extraordinary jurisdiction on the High Court to issue high prerogative writs for enforcement of the fundamental rights or for any other purpose. It is wide and expansive. The Constitution does not place any fetter on exercise of the extraordinary jurisdiction. It is left to discretion of the High Court. Therefore, it cannot be laid down as a general proposition of law that in no case the High Court can entertain a writ petition under Article 226 of the Constitution to enforce a claim under life insurance policy. Here I'm asking a lesser relief actually. It is neither possible nor proper to enumerate exhaustively the circumstances in which such a claim can or cannot be enforced by filing a writ petition. The determination of the question depends on consideration of several factors like whether a writ petition is merely attempting to enforce his or her contractual rights or the case raises important questions of law and constitutional issues. The nature of the dispute, the nature of inquiry necessary for determination of the dispute, the matter is to be considered in the facts and circumstances of each case. While the jurisdiction of the High Court to entertain a writ petition under 226 of the Constitution cannot be denied altogether, court must bear in mind the self-imposed restriction consistently followed by the High Courts all these years after the constitutional power came into existence in not entertaining writ petitions filed for enforcement of purely contractual rights and obligations which involve disputed question of fact. The courts have consistently taken the view that in a case where for determination of the dispute rate, it is necessary to inquire into facts for determination of which may be necessary to record oral evidence or for proceeding under 226 of the Constitution is not an appropriate forum. The position is also well settled that if the contract entered into between the parties provides an alternative forum for resolution of disputes arising from the contract, then the party should approach the forum agreed by them and the High Court in the writ should not. At the cost of repetition, it may be stated that in the above discussions, we have only indicated some of the circumstances in which the High Courts have declined to entertain petitions under 226 of the Constitution for enforcement of contractual rights and obligations. The discussions are not intended to be exhaustive. This court from time to time disapproved the High Court entertaining a petition under 226 of the Constitution in matters for enforcement of contractual rights and obligations, particularly where the claim is one party is considered by the other and adjudication of the dispute requires inquiry into facts. This law has now actually undergone a major change after MP Power, sugar mills and all that. 11, my lord. The position that emerges from the discussion in the decided cases is that ordinarily the High Court should not entertain a writ petition filed under 226 of the Constitution for mere enforcement of a claim under a contract of insurance. Where an insurer has repudiated the claim, in case such a petition is filed, the High Court has to consider the facts and the circumstances of the case, the nature of the dispute raised, and the nature of the inquiry necessary to make for determination of the questions raised and other relevant factors before taking a decision whether it should entertain the writ petition or reject it as not maintainable. It must also be kept in mind that in case an insured or nominee of the deceased is refused relief merely on the ground that the claim relates to contractual rights and obligations and he or she is driven to a long-drawn litigation in civil court, it will cause serious prejudice to the claimants or other beneficiaries of the policy. The pros and cons of the matter in the context of the fact situation of the case should be carefully weighed and appropriate decision to be taken. In a case where claim by an insurer nominee is repudiated, raising a serious dispute, and the court finds the dispute to be a bona fide one which requires oral and documentary evidence for determination, then the appropriate remedy is a civil suit and not a writ petition. Simply when a plea of fraud is pleaded by the insurer and on examination found prima facie to have merit and oral and documentary evidence may become necessary for determination of the raised issue, then a writ petition is not an appropriate remedy. I am actually culling out where I don't fall under. I am in this. 12, please have a look at. '12 is primarily under 45, but that's for life insurance and goes into repudiation. But where your lordships have always interfered is where I can show that this does not require any investigation into facts. Then a writ petition is not there is no alternative remedy that comes in. This has now been followed. This is 2024 SCC Online Calcutta 855. This I had argued this matter against the insurance company, thankfully favorably. And the question had come up whether it would be maintainable and to what extent the court can go. Here, in fact, to be fair, I don't think I need to trouble your lordship. Mr. Sinha has very fairly not raised that point of maintainability of the writ petition. So my endeavor was only to highlight that I am restricting my scope of challenge to the part where the words have been imported. This does not require any investigation into facts. My prayer before your lordship is not even for the amount. It is only for quashing and for the consideration of my claim on the basis of the policy as it exists. These are my respectful submissions for.
Which para you are relying upon, Calcutta?
This one, 35 to 42, your lordship will just 35 to 42. Please have a look at one.
Yes.
34 also, if your lordship gives it a one cursory glance. In any event, there was no application of mind by the respondent insurance company while repudiating the detailed expert report which has also been accepted by the surveyor. The judgments noted above undoubtedly say that the surveyor's report is not binding on the insurer. So and so it was observed that the surveyor's report is not sacrosanct and binding on the insurance company. However, in the same breath, the insurance company cannot simply brush aside the same without giving any reason therefore. So and so it was clearly held that if the insurance company seeks to rely on an exclusion clause, cogent evidence and reasons have to be given by it for so relying. This and then that whole thing is followed. because after all, what they do is they're relying on an exclusion clause. So whenever, because of the nature of the contract, it has to be read in my favor. Here they've gone a step ahead and added to the exclusion clause.
Thank you.
But 40 and 41, your lordship will see, just, I'm not placing it, no, I'm just indicating that there the court actually does not, once it's fined that it's arbitrary, it doesn't sit and twiddle its thumbs. It says, I can't give you the money, but go back for another consideration where the consideration is not unjust. There has to be an application of mind to the policy as it exists. That is all that is.
I'm thankful to my learned friend that he has curtailed his issues only to this much. I thought he would argue much more. But what I understand, his principal challenge is that there have been words which have been incorporated, which were not present in the insurance agreement. And that is why it's prejudicial, arbitrary, Article 14, as we are not going into Article 19 anymore. Now, I will say that it is not maintainable because the facts have to be there. Otherwise, that's why I said that point I cannot argue before anything is placed. I'll come, but that I come to end. Lordship, the problem begins in this matter, which has been kind of, if your Lordship actually sees the writ petition, there is no mention of that. But it is there in the repudiation and otherwise. It starts with commingling of products. Now, what's a commingling of products? Now, the commingling of a product is basically like this. Here we are getting coal from Denver. Now, two companies buy the coal. 50% by this company which is there before you. There's another company which has bought it and that was taken down in Paradip. Two companies. Now, what happens is when there is a question of commingling, because there will be an interaction of another third party with regard to the vaults, because they will be taking out from all of the five stores in the ship, and they take it out from the top. The first one. So commingling is an important criteria which has to be mentioned to the insurance company. Contract of utmost good faith and full disclosure is required. There is no disclosure. There is no disclosure, your Lordship. First thing, if I am saying anything wrong, that will be shown. I may be shown from the documents, insurance document, anywhere. And in fact, your Lordship, there are lots of correspondences which, if given an opportunity to file an affidavit, I would have shown, where the surveyor appointed by them, they only say that, well, the insurance company has to look into the commingling. If there is commingling, it should have been commingling clauses in the insurance contract if they are present. Now, that can only be present if I know of them. I have no actual knowledge of the commingling till it comes, and then we come to and have these problems. That's the first point. So on that ground alone, repudiation is justified. I don't even have to go into whether there was moisture or not. There was no moisture.
But your reputation, can you see that?
That commingling is also there. There's one paragraph which has been read. I will come to that. I'll come to that. But I will meet his points head on first, and then I'll come to that. Now, your Lordship will see what is being said about the agreement, and your Lordship, I'll take you, Lordship, back first to 226, I think his page number 226, which you were showing.
227.
227. Paragraph 6. 227, paragraph 6.
Yes.
The question which has been used is moisture and deterioration of quantity. And he said these were not present. Now, your Lordship will please traverse back to page, I think, 83. Exclusions.
83.
83.
Yes.
Your Lordship sees exclusions. Please see number 2. Unexplained shortages. Isn't it called quantity, deterioration of quantity, unexplained shortages. Somebody cannot just play with the word and say that it is not there. It is very much there. And then your lordship sees number 4. Oh, sorry, number 3. Sorry, number 2 and then number 3. Moth condensation, insect infestation, stains, moisture. Is the word moisture there? Now, so it is not that we have incorporated something suddenly out of nowhere. Now, one may challenge the interpretation of this. The interpretation of these documents may be challenged.
Yes.
What is moisture in paragraph 3, that whether that contaminates that moisture or not, all these can be challenged, whether unexplained shortages, and that challenge is not forbidden to them. As your lordship correctly said, go to a civil court, find out what is going to be, because this will require evidence.
Correct.
Whether there is, what is the business practice, what is the insurance practice, insurance usage of these words, all of this will come in. But to say that we have fabricated documents, or we have, and this is to the government employees. Imagine if there is an order goes in, an insurance company, government insurance company is in taking up words from nowhere and incorporating it to repudiate contracts. This is the allegation today. That allegation on a prima facie view does not write. Your lordship, these words are clearly there.
Yes.
Your lordship, I'll just take you. This is page 23. 23 of the writ petition in their averments. What do they say? From the middle of XXXI, the paragraph XXXI, from the middle, the petitioners submit. Your lordship has found the middle of it.
Yes.
The petitioners submit that the respondent number 1, by its letter dated 12th August 2025, has falsely, mischievously, materially, and wrongly altered the policy exclusions clause by inserting the words moisture and quantity, which do not appear in the contract.
Yes.
Your lordship, I have already indicated how moisture already is there in that contract, and shortages, unexplained shortages is being said as, I don't think there is a strange leap or it is a something which is arbitrary to say that shortages means loss of quantity.
Yes.
And your lordship will then see what they have done. They have stated the policy in which it says losses due to blank heating. What they have done is they have quoted number 4 from page 83, not 3, in which moisture appears. The word moisture appears. As I said, your lordship, they may have a really good case by saying our interpretation of the agreement may be wrong. But an interpretation of an agreement going wrong cannot be deemed to be arbitrary. That is a commercial transaction. And a commercial transaction, interpretations may vary. That has to be decided by a court by taking evidence, and not by a writ court which say that if I had not used my mind,
that is different.
That is a completely different thing. If I had actually incorporated words which were not there, that is different. But do their words appear in the exclusion clause? They do appear. That is first. Next, your lordship, the question with regard to, which will baffle, is with regard to the moisture. Lot is being said about clean bill of lading. Now, there are two sets of bills of lading. Again, these are questions again which will come up in our, because I don't have all documents. I cannot really say which bill of lading this is. There are two. One which is the received bill of lading, that has already come into the ship. One, and the other one received for shipping. There's another one which happens. Now, which this one is, I actually,
Three.
master's bill of lading.
There will be a three bill of
Yes,
lading.
the other one is a,
One will be the same port.
yes.
Second will be in a vessel.
Yes.
Third will be the port where the material is to be delivered.
Very well. I'm not that too, I'm not even going into, because we are only dealing with a situation which has happened first. So we are dealing with two sets of bills of lading. Now, which one is this? One before or after? We don't know. That is one. Then your lordship will take two documents. My junior did a lot of research and reading up. He was very keen for me to show these documents. Your lordship will come to page 123, 124.
Yes.
This is the master of the ship. Your lordship, this is to the companies which are saying. This is to inform you that while staying several days in Davant anchorage, weather condition was unstable with continuous light to heavy rain due to hurricane season. Loading of pet coke into that ship, that is, said cargo load from terminal to the vessel.
To the vessel with the presence of the light rain.
Light rain sometimes.
Yes.
It has been noticed that the pet coke cargo exposed to rain at the same time due to pet coke stocked outside the terminal open area and may cause excessively wet. Pet coke condition remain unpredictable prior to the load of the vessel. So this is a document which has been given notice, not never declared to the insurer. They have notice of this.
What is the date? 5th July.
It's 5th July. This is 2 days before the bills of lading which has been shown. Now your lordship will have a look. Another document.
When the loading was done?
7th, your lordship.
7 July.
Yes. I think it must have started between 5th to 7th, but bill of lading which is being shown here, that is of 7th. I don't know, your lordship, because I don't have any instructions, no information to us. We are only talking about the documents which we have in front. And now your lordship will come to page 161.
Yes.
Your lordship sees 161, statement of fact.
He'll take some more time.
He's asking me to make sure that I speak till he comes back. Your lordship.
Number 10. So my matter is item number 10. Will it be released? Then
Yes.
Item number 10.
You will take time.
It is
Na?
item number 10. Will it
Appellate side matter, release other matters. Release.
Yes.
Your lordship, page 164 in this. 161 is a report.
Statement is a statement of fact.
Statement of fact.
Yes.
And in this page 164, there is a master's remarks are there.
Yes.
Here, 8 and 9 are refuted. Entire cargo
Where
discharged at Haldia port in the
from your reading? Clause?
Page 164.
Correct.
On top, master's remarks.
Correct.
C. C.
Yes. Yes.
Before that, your lordship will see all cargo discharged as per BL.
Yes.
P.
Receive remarks 8 and 9 are refuted. Entire cargo discharged at the Haldia port.
In same order and condition as loaded at vessel's load port. Vessel is only a carrier of cargo and not responsible for quality of cargo. Vessel confirm no seawater ingress inside the cargo holds and vessel loaded cargo at load port with moisture content. With moisture content, it itself says. So, irrespective of the fact, now let's your lordship says, even it is not there. Nothing is there. My clause is not there. And their case at the highest. Can they claim an insurance with regard to a material? What they bought and loaded? That is not possible. That is not possible. This is exactly what is happening here.
No, that's why. What the case made out by the petitioner, because the water found in the hatch
came after loading.
Correct. What after loading, whatever it may be.
No, your lordship. Before loading, if they loaded
if it's taken to that,
yes.
If it is taken to that, then the petitioner has to prove from the master of the vessel is the owner of the vessel.
They have to prove they have taken no action against the ship.
So it has to be proved by the petitioner. Yes, there was a water in the war subsequent after loading of the vessel and loading of the materials. The water went inside the hatch, due to which the material wet, and when it has been taken out, moisture created.
Now,
and due to the moisture creation, the contamination.
Yes. Now, two other facts are important. There was one thing which is it would startled anyone that 2022 the matter thing happens, and after 2 years why the surveyor is in. Now, important thing is when they lodge a claim, the documents are there. We ask them to provide an estimation of what the loss is. Depending on action will be taken. Estimation will be asked. No response to that. They never ask for. I'm not saying that is the reason why their case should be denied or nothing, but I'm just explaining what the sequence of events, what happens. It is only after.
But once the insurance company received the information with regard to damages and all these things, then it is the duty of the insurance company.
Your lordship, that is true.
Immediately take.
No, your lordship, I'll tell you, there are lots of small claims which happen. Various small claims. For everything, a surveyor and everything is not appointed. Cost of surveyor would be way more.
But you're propagating in the online on all these things. It will be settling within 2 days. So come with this insurance company.
That is true. That is true. That is why.
Whether that plea can you take at this stage?
No, I am not taking that. I am not taking that. Your lordship, I am not taking that. I am not taking that point at all. What I am saying is, they did not provide, and because of which, whatever latches, there was a delay in appointment. Now, in this time, they also did not inform us. There is no letter which informs us that they have appointed a surveyor. They have not done that. Maybe we would have gone with the same surveyor because that person may be also impacted. But they do not inform us that they have appointed a surveyor also. There is no documentation to show that they have appointed a surveyor that is informed to us. Now,
yes,
upon knowing the surveyors, we write to them. Your lordship, these are documents which otherwise I would have. I can't at this moment because I'll give them a call. We have reported it quickly.
Yes.
Now we write to their surveyors and we get a reply. your lordship comes to the second one, which is their reply.
Single one.
No,
Double.
double. That is their reply. Now these are all
Reply of the insurance.
no. This is the reply of their surveyor, which
Reply
was
of the surveyor of
to the insurance company. Lordship comes to III, whether the water found in the hatch mixed with the cargo was seawater or fresh water.
I. Whether the water found in the hatch mixed with the cargo. Yes.
Today, it is difficult for us to confirm whether the water found in the ship's hold was seawater or not. Their case is that we did not appoint, they appointed someone. On the basis of that report, the entire thing has been finished. That person says we are unsure whether it is seawater or not. If it is not seawater, then there couldn't have been a problem while at sea. It says it is difficult for us to confirm whether the water found in the ship's hold was seawater or not, unless silver nitrate test is done. However, ingress of water in the ship's hold might be caused due to mechanical fault of the ship. If you examine the comments of the master carefully in the SOF, you will find that the master commented that there was no entry of seawater, but did not rule out the entry of fresh water in the ship's hold. Hence, it can be said in the balance of probability that the water found in the ship's hold was fresh water. Now, your lordship remembers there was a letter of protest by the master which said that the rains, it was getting drenched in the rains. That's fresh water. Yes. That is fresh water. Now, all I am saying is they may have the best legitimate case. But at the end of the day, that's a case for evidence. That is a case for evidence. Now, the other aspect, my learned friend, some judgments here shown, I don't have the copy immediately, but
only the para 9.
আমি জানি কিন্তু আমার হাতে নেই দেখ প্যারানাইট ঠিক বলেছিলাম ভালো বলেছি Your Lordship, one important distinguishing feature with those judgments where LIC and all are involved, and today in 2025 is a complete change of how the legal framework now has changed. And I will explain. All those judgments relate to personal insurance. These are all personal insurance. These are commercial insurance. The one thing to say it's a contract, yes, it's a contract. But there is a difference being an insurance contract and insurance contract, which is a commercial contract. These are all commercial contracts. If everybody starts coming to repudiation or anything like that to coming to court, then the court will only be doing commercial contracts because every ship, thousands of contracts are in.
Several judgment says.
Several judgments.
Insurance, there is no difference, but only with regard to the commercial contract.
Commercial contract. And another important issue, which one of the leading considerations which was there, one of the main considerations which was there, is that the person will be dragged for years of civil litigation. That was the reason we have. Now, your lordship, fortunately for the insurance company and everybody, and unfortunately for them, that's what I wanted to say, is that there is a Commercial Courts Act. Commercial insurance will now go to commercial courts, not go to normal courts of law. Commercial courts, whether they follow it or not, is again a different thing, but the regime it has to finish within a particular time period. So there is no question of years of dragging. The entire bedrock reasoning behind which it was said that we should not be doing is not there. So to summarize what I wanted to say, Your Lordship, one, these judgments, though still perhaps hold forth, otherwise are not applicable in our case. Because it's a complete commercial nature of the contract, cannot be done. I don't, unfortunately, there are judgments, Your Lordship, which is division bench judgments. I don't have copies. Once it was stating, I was showing.
Let me just indicate one thing. I will be beseeching Your Lordship to allow me to come day after tomorrow to just give instruction on this.
Mr. Banerjee, Mr. Banerjee,
yes,
frankly, I say to you, take your client, take the instruction whether you want to continue, because if any observation will come in,
I understand but I was actually using this document as a ruse to take that instruction. Lordship keeps it day after tomorrow.
If this document is, that's what I'm telling, because this document the court cannot
Cannot, yes, I
Entertain.
understand the limitation. Kindly keeps it day after tomorrow. By then
Take
he'll read up the judgments also.
Take instruction.
I'll take it,
Because
sir.
no,
Come.
if this court, okay, if it is in your favor, it is. If it is not in your favor, then it will be difficulty in your suit also.
I understand.
That also
I
take
understand.
care of.
Gives me a day. Let me come back on Wednesday and
No
then.
problem. The counsel for the parties have argued the matter at length. Counsel for the petitioner place for it. 2 days, 1 day.
Wednesday, Mullah.
A day's time. Let the matter appear on
So
20.
Lordship will keep it at 2 o'clock.
I don't think 2 o'clock we will get time. 26. 26 okay time hai dekho.
नहीं
At 2.
I just want to include what article.
11 ही फिक्स है 26 को नहीं होगा 27 को नहीं 26 को फिक्स है मैटर 26 27 तो क्रिमिनल और उसका है ना
Your Lordship, 27th is also fine with both of us.
Whenever, my lord, 20.
2 o'clock is safe because Your Lordship, when we finish the matter.
एक या 2 तारीख
28 हम यार वो ये थे सबको. No, we can come back next week also if your lordship.
First December at 2 p.m.
Very great. Very, very good.
My Lord, may I humbly pray that my Lord may be pleased to take up item 20, my Lord. In view of my ailing condition, may I pray I shall not take more than 10 minutes. Item 20. Item 20, my Lord.
Just a minute. Ella. It's a pin code, is it? Item number? Yes, boss.
20, my Lord. 20. If it be my Lord's kind pleasure, I am not keeping well. Kindly take up 20.
No, I am already having a fixed matter at 3 p.m., sir. Come tomorrow. Call the next
Tomorrow, may I get some precedence, my Lord?
Come tomorrow. We'll see how soon, how far we can go. Call the next.
Item number 9.
Yes, whisper. Nobody is there.
9.
9?
Item number 9. Appellate side.
Okay, let the audio set. Not good.
This the matter was mentioned in the morning on behalf of my.
Yes.
But in this matter, the matter was mentioned. I'm led by the Advocate General and Mr. Jishnu sir. My lord, your lordship has indicated to come back for the convenient date. My lord, any date on week beginning from 8th of December, 8, 9, 10.
Your Lordship, if we can get something on the first week of December. If we can get something on the first week of December, Your Lordship.
Mr. Jishnu sir had some difficulty in the first week. He has given me his
Then
tentative.
can we have something this week, Your Lordship?
This week is not because other matter already fixed.
My lord, anytime next week, my lord.
Let me see.
If any 3 dates could be fixed, my lord. In
I
place
was
of
praying for
22.
8th, 9th and 12th. 8th, 9th and 12th.
9 or
My lord may fix at least 1 day next week, my lord. Or else this will go beyond the vacation, my lord. My lord fixes a day anytime next week, my lord, and then it may continue for 8, 9, 10, 12 the week after, my lord.
रिट पिटिशन 3 बजे 3 बजे किसका रिट पिटिशन तो पहले से फिक्स है कब 2 तारीख 3 तारीख कुछ नहीं है ठीक है 9 तारीख 9 और 11 9 and 11 at 3 p.m.
My lord fixes one more day, my lord.
9,
It
8,
was already
I was paying 8, 9, and 12 because 11th same connected matter is fixed in the Supreme Court. It is appearing in the list. The regular hearing matters are taken up on Wednesday and Thursday.
not
So I was
same
requesting
connected matter, not
the
same
same
connected matter.
councils will, all the council will be there in Delhi.
Not from us.
Mr. Saha will be there, and
matter.
This Chatterjee International versus same. That's why I was saying 8, 9, and 12.
That is the interim order.
There is a
No,
hearing.
my lord, it is
hearing.
not a connected matter. বলছে Supreme Court এর সাথে
But the
Well, that matter, well, that matter has absolutely nothing to do with this matter. That's an entirely different contract.
The councils are the same.
Well, that is no ground, lordship. The same council may appear in.
It's appearing for the
matters.
same agreement.
It
It's
has
appearing
nothing
for
to
the
do with
same
the matter.
agreement.
Well, let not these misleading submissions
No,
be made.
it's not a misleading.
Absolutely
My
misleading
friend knows the matter is appearing.
I was there in the matter. I know the matters are different.
Then this is not
Please,
different.
Don't mislead the court.
No, I'm not misleading you.
Why 11 is not possible for you?
That Supreme Court, that court takes up regular hearing matter on Wednesday and Thursday. That's the problem.
After lunch.
next week and then 8.
That is after lunch. I am fixing after lunch.
But
Not
in Supreme Court is fixed.
My lord, Supreme Court has nothing. Lordship kindly takes my word for it. Entirely different matter.
Let it fix 8, 9, 10, 11. Your lordship is fixing 8, 9, and 11.
9th at 3 p.m. 10 at 3:45 p.m. 11 at 3 p.m.
8, 9, 4 days.
As per
My lord, I have only one request, lordship. Could it be a little earlier than 3:45, lordship? Because these matters will.
That my diary doesn't. It is original, total originals. I could have been adjust, but I could adjust the appellate side also, criminal also.
Lordship, I apologize, lordship. I know lordship is a very. Well, one day next week in that case, lordship. Any day next week.
Total, my diary is totally packed. And I cannot.
It will kindly consider, lordship. We are enjoying this award, not being able to do anything despite lordship's judgment.
What can be?
Lordship, this is how it's been. I mean, if it's their intention that they'll delay the hearing of this matter, that's a different issue.
But 9 December at 3 p.m. 10th made by the council for the respective parties. Let the matter appear on 9th of December 2025 at 3 p.m. 11th of December 10th of December 2025 at 3:45 and 11th of December 2025 at 3.
That, my lord, please, lordship will kindly consider our plight. We are only doing our clients.
If you take the diary of my court officer and tell. If
Grateful, lordship. But my only request will be, lordship will try and do us some justice in hearing out this matter.
This court is only for the justice. Only
we know that lordship done it before, but lordship will kindly see to it, lordship, because
to all.
the entire purpose of the Arbitration Act has been defeated. In this matter.
3 dates.
Just through
you complete on 3 dates, then we'll see to that.
Great.
Then they will argue.
Great.
Yes, next.
Lordship, before Lordship takes item number 1, may I permit to mention one extension of interim order?
Which matter?
Lordship, it's mentioning extension of interim order. The order is expiring on 28th of this month. Upon notice, Lordship. Lordship, the stay order was given by a coordinate bench.
Coordinate bench? So why you are mentioning here?
No, Lordship's predecessor bench. I'm sorry, Lordship. I'm sorry, Lordship.
तो WP list में नहीं है. It is not in the list.
Not in the list, Lordship. Lordship, I mentioned
27. Bring on 27 has to be mentioned.
Lordship, grateful.
Yes, call the list.
My lord, item number 1 is appearing at my instance. My lord, your lordship was pleased to
grant, my lord, letters of administration.
Ah.
Thereafter, my lord, on June 20th, 2025,
Ah.
my lord, your lordship had recorded our submissions and permitted us to file, my lord, 2 affidavits of undertaking, my lord, that the fixed deposit shall not be, my lord, revoked. My lord, we have prepared the affidavits. My lord, in paragraph 4, my lord, only one detail of the, my lord,
Paragraph 4.
my lord, June 20, 2025 order, your lordship. My lord, may I? Yes.
It is submitted the sureties will furnish their undertaking of stating that they will not revoke the fixed deposit.
Yes.
Yes. Then.
My lord, lordship had directed security for 23 lakhs.
Hmm.
So, my lord, we have, my lord, other fixed deposits, my lord, which
What
will
is the
cover.
amount that?
Yes.
What is the amount in the other fixed deposit?
I'll indicate your lordship. My lord, one is for 5,49,366. Other is for 5,63,298, and the third one is for 15 lakhs.
Other than this, for 6,49,000.
My lord, two others.
2 others.
Yes,
That's
yes.
what is
Lordship, may I just hand up, my lord? The fixed deposit receipts are here. My lord, at page 2, I have stated the details, and my lord, at
This is the first one, 6,49.
yes, your
That's
lord.
the first one.
Yes.
And this is the second one.
Yes, my lord.
What is the amount? 15 lakhs.
15 lakhs, my lord.
15 lakhs.
Yes.
So these are the 2.
My lord, total 3. My lord, one.
Where is another one?
My lord, will kindly take Vijay Kumar Singh's, my lord, undertaking. Vijay Kumar Singhal, my lord, at page 2, paragraph 4, A and B. My lord, these are 2 accounts, and one is for 549,336, 563,290. And the one which is recorded in your lordship's order.
No. In this Vijay Kumar Singhal, kindly come to Annexer A.
Lordship.
Annexer A. What is the maturity? What is the amount?
560. But mature.
My lord, payable, my lord, itself selves, and there, my lord, just above that, 649,711.
6,39,000.
711. This is the amount, my lord, which is recorded in your lordship's order. My lord, they have given the maturity amount.
Correct. 649, 711. That is
Yes.
the B.
Yes,
This is
your
the
lordship.
B.
That is B.
Now this is the second one.
Lordship.
So you are telling the 3. So where is the other one?
Lordship, I'll show. My lord, the other affidavit, Ruchika.
You're confused, sir.
My lord, Ruchika Singhal, my lord, 15 lakhs.
So correct. Single 15 lakhs.
Lordship.
Correct.
Ruchika Singhal 15 lakhs.
15
Lordship.
lakhs.
Yes.
Which a maturity come to maturity 1548.
Lordship.
And these are 6. These are the only 2. Where is the third one?
Because the second ta kotha hai. My lord, just the page prior to that, my lord. This is ICICI Bank.
This one?
Yes, your lordship.
A.
A.
Ah.
My lord, and then 3, my lord, total. This ICICI
So that's
Bank.
I'm telling. Prior to that, you are telling that this is the incorporation. This is continuation with the B.
No, your lordship. The maturity amount and that amount, my lord, I couldn't match.
So it is in the name of nominee Rekha Singhal. In whose name?
My lord.
Who is the beneficiary of this deposit?
My lord,
Vijay Kumar Singhal.
Yes, your lordship.
And second one is Vijay Kumar Singhal.
Yes, your lordship.
And third one is this one
Ruchika
is
Singhal. My lord, the undertakings are by them.
in whose name? The third one?
Ruchika Singhal, your
Ruchika
lordship.
Singhal.
Yes, your lord.
The matrix list is to be mentioned for modification of the order dated 20 June 2025. By the said order, this court allowed the petitioner and this court directed the sureties to furnish an undertaking in the department, and if the undertaking is filed by the sureties, the same may be accepted by the department, and department directed to communicate the undertaking to the concerned bank. Counsel for the petition submit that in the said order, this court has only recorded the details of one deposit receipt being number 0932208 in favor of Mr. Vijay Kumar Singhal for a total amount of rupees 6,49,711. But there is another fixed deposit of Mr. Vijay Kumar Singhal. That is the fixed deposit that is in connection with the account number 125413031011 for an amount of rupees 6,39,231 of ICICI Bank, and the maturity date is 29 December 2025. And another fixed deposit of Srimati Ruchika Singhal with respect of the fixed deposit receipt number 17419431 dated 13th March 2025 for an amount of rupees 13th March 2025. Maturity date and that is over.
My lord, it is auto renewed. Your lordship will see unlimited auto renew, no auto closure.
15 lakhs, and the maturity amount is rupees 15,48,055. Accordingly, the order dated 20th June 2025 is modified by allowing the sureties, namely Vijay Kumar Singhal and Ruchika Singhal, to file an undertaking with respect of the aforesaid fixed deposits, stating that they will not what you stated.
My lord, paragraph 6, I further undertake not to revoke in cash transfer or otherwise.
In cash the said fixed deposit without the leave of the court. The petitioner is further directed that the fixed deposit of Ruchika Singh may be updated as on date and submit the same in the department.
Apologize for troubling your lordship, my lord.
Yes.
Lord, may I be permitted to take back the original, my lord?
Well, this is the matter where arguments were going on.
Yes.
The last occasion, my learned friend was not there. My lord, I have made my submissions, but we just want one more case to cite. If it would please my lord to allow my learned junior to do it, because your lordship knows today is the full court reference and I have a duty there.
Yes.
So, my learned friend.
My lord, may I hand over the, my lord, the judgment is a part of the written. बोले दीजिए AIR 2018 Supreme Court 2847 बोले दिले
বলে দিলে হবে না তার কারণ হচ্ছে I am not ready with this. You should have given me one.
My lord, the citation is AIR দিচ্ছি দাদা AIR 2018 Supreme Court 2847. My lord, it is a part of the
zipper.
Yes, Apollo zipper. My lord knows the facts. My lord, may I just take your lordship through paragraph number 67, 68 to 71. My lord, there is a discussion on
paragraph
67, 68 to 71.
Yes. Yes.
My lord, the question which arose here, there are three questions which arose. One of which was whether the Transfer of Property Act will apply because the rent was 40,000 for that premises, or whether, my lord, it was contended by one of the parties, the rent was actually less than 10,000 and therefore West Bengal Premises Tenancy Act will apply. My lord, the Honorable Supreme Court came to a conclusion, no, that the rent was 40,000, and taking that decision in mind, my lord, they went to these discussions as to which act will apply. My lord, kindly come to paragraph 68.
Yes.
My lord, paragraph 67. In our view, the monthly rent of the suit premises was rupees 40,000. So, my lord, this is a decision that the inference the Honorable Supreme Court comes to. My lord, then paragraph 68. This takes us to examine the next question as to whether the suit filed by the appellant invoking the provisions of the TP Act was maintainable or it should have been filed under the Tenancy Act. My lord, this is a question raised by them as well. In our opinion, the appellant rightly filed the suit by invoking the provisions of the TP Act. It is for the reason that once the monthly rent of the suit premises was found to exceed the limit prescribed under Section 3F of the Tenancy Act. My lord, in our case, it's more than 1 lakh. The provisions of the Tenancy Act had no application to the suit premises. Section 3F of the Tenancy Act says that any premises let out for non-residential purposes when carries rent more than 10,000 as monthly rent in the areas included within the limits of municipal corporation, the provisions of the Tenancy Act will not apply. In the case at hand, the monthly rent of the suit premises was 40,000, in our case 1 lakh above, and therefore the appellant was well within their right to file. My lord, a summary suit was filed, my lord, a chapter 13A application had been taken out, was well within their right to file the summary suit against the tenant's eviction and for recovery of the arrears of rent by taking recourse to the provisions of the TP Act, read with the rules of the, my lord, the Calcutta High Court rules. My lord, these further supports our case. My lord, once it is beyond 10,000, my lord, it is the Transfer of Property Act which has to be applied. The Premises Tenancy Act has no application. My lord, this is only one judgment on which we are relying.
Thank you.
I'm so grateful, my lord.
Yes.
Lordship, all along.
My lord, there's one more thing. My lord, just I may hand over for it. My lord, there's one more judgment which we have handed over along with the notes. My lord, it is my lord, between the same parties, a separate suit had been filed pertaining to a different portion of the same premises. I'm just my lord, in that judgment, my lord, Justice Joyanto Biswas, as his lordship then was, my lord also discussed, my lord, as to whether the Premises Tenancy Act shall apply or, my lord, whether the Transfer of Property Act shall apply. My lord, the same party, same question had been raised over there. My lord, there also, my lord, the rent for the premises was far above 10,000, my lord, and he came to the same conclusion. My lord, that was not touched by any of the division bench or the Supreme Court to which it went.
Yes.
And my lord, ultimately the eviction decree was passed. Well, in our case, we've recovered possession, so it's largely a question of mean profits.
Yes.
I'm sorry.
Copy the delay देखिए. My lord, what I argued from beginning till this date, it's not the case that by operation of law, 1956 Act was not applicable, then under new Act, I will not come under. Agreement was entered upon that time.
Yes.
So agreement was entered much prior to the 10th of July 2001. So lordship, the question which I raised before the lordship, at that point of time, lordship, let's forget the substantive law. Let's see first the procedural law. Lordship, the protection against eviction is the word issue in 12.6 today, 6.12 that time, and under 106. So, lordship, what are the protection under the statute? There, the protection is 1956 Act. Except defaulter, I can put the money and can protect myself. Under 11.6, I have 7.1 and 2. The new Act 7.1 and 2. In 7.3, I can challenge the landlord. We are not challenged. Now, lordship, kindly see 106. 106 has the two protection. What are those? The statutory protection is a notice of some shorter period, longer period, that's a different. So one is the notice and another, it's a monthly tenant. No doubt, up till this, I am with my other side. But what will be the terms of the monthly tenant? I tried to argue and distinguish between a statutory guideline of protection and a protection which you inbuilt or you build for yourself. So, in 1956 Act, I had my statutory protection
as well as the inbuilt protection which I have made for myself. Now, by operation of law, one will go. But again, now if we see that, suppose today I am making an agreement with someone in a commercial agreement, this can be the best they can pitch their case this high, that as if today they are entering into a deal. So the new law is there, settled law is there. So if today I enter into an agreement under 106 till 111 Lordship, if we see, so I have a right to add or subtract certain clause in a monthly tenancy.
Yes.
So in a monthly tenancy, I have got certain rights and contention. Now, Lordship, it boils down to this. If someone consciously not put anything into agreement, then what is the effect of that? The only thing we have to consider.
No, see. Earlier there was old Act 57. The implication of the new Act 57 repealed. What would be the effect?
Lordship, let's think like this. This agreement is made January this month, February this year, 2025. It takes me there. Monthly tenancy, transfer of property. Now, Lordship, the agreement they have said we are abiding by the agreement. Lordship, I have seen, I have given question.
Correct.
I have questioned that gentleman that whether are you giving effect to it, he said yes. So now, Lordship, when there is a written agreement between the parties, when the tenure is not fixed.
Monthly is there. Monthly tenant.
So monthly tenant. So now in the monthly tenant, in what criteria the suite will, as it available to him under 106, will also be available here? That's the question I am trying to make. If it is so, whatever your agreement is there, I will invoke this. In that case, yes, Lordship, what my learned friend is saying is correct.
Yes.
But in a case when there is an agreement, parties are agreed to it, and today, Lordship, and today the occupational money, occupational charge is being given to them. Till that, this is also not disputed. So now they say that we received under the court instruction or whatever it is. So, Lordship, there was no tenure fixed. So if it is not tenure fixed and they continued for more than that period, 97 to this 2008 they have done. The act came into 2001.
Correct.
So July 2001. So they continued under 2008. I'm sorry, ma'am. I need 5 minutes more. I'm sorry. Lordship, I need 10-15 minutes time.
Counsel for the plaintiff has filed written notes of argument after serving the copy to counsel for the defendant. Counsel for the defendant has argued the matter for some time, but due to paucity of time, hearing could not be completed. Right? नहीं है फिक्स है क्या 17 December at
Lord, I'm deeply impressed.